But in this case, record was called for.
Yes.
The record was called for in this case to verify whether charge sheet was issued by the date of promotion.
My Lord, Lordship, yes, Lordship, may kindly have a look to the order dated 12/12/2025.
No, 13 to 26. Another order is made.
My Lord, what I want to submit, my Lord, in that order, your Lordship directed call for the promotion file in question. So also original file in DP number 2 of 2011, along with an official. The records are with me.
Okay.
Records they have submitted, but the man who will come and assist your Lordships in questioning the queries.
Some other day.
Some other day, Lordship may fix a date on Monday also. I will call them. Monday or any other day, your Lordship to 15th, my Lord.
Okay.
Specifically.
With the request of them.
I'm withdrawing this.
Withdrawing?
Yes.
Not happy with the court?
No. Certain developments have taken place. I've indicated in the memo, certain developments have taken place.
The other day, says that
Yes. Again, that apart, I'm withdrawing, there's no issue on that.
Protect counsel appeal for the plaintiff. Seeks leave of the court to withdraw the complaint. So he has filed a memo dated so and so which reads as that next level. Leave having been accorded, a complaint is disposed of as having been withdrawn. With liberty.
Academically also, but that apart, I have that Bombay High Court judgment which you're not sure is referring.
Got it?
Yes.
Thank you.
I have it with me if you're not sure. I can share it.
Yes, sir.
Your Lordship,
Go to the law.
I will see the page 8.
Payment shall be made within 8 weeks.
Okay.
They are not done. Why, Mr. G, why are you driving people to the contempt jurisdiction unnecessarily? That will embarrass the officers also. Advise your officers to comply with the court orders. They should respect them.
Obviously, I'm also.
Lord Rama respected the
Yes.
verdict of Dasharatha.
By
Go
heart.
to forest.
Yes.
Dasharatha did not question. Not only Pitruvakya Paripalanartha, but because he is our king.
Yes.
If we do not follow his words, who will follow? Same applies to this.
Well,
Tell your officer, they should abide by the issue of police notice. Returnable within 2 weeks, post law. 23. Yes,
Postal to only.
23. In content matters, you have to fix a date, na? After 2 weeks under your rules.
Next week your bench is there, man.
Next. Item. May I please, your Lordship? This matter regarding regulation matter.
my Lord.
Your Lordship judgment is.
Today,
State very apex court.
They have approached the Honorable Supreme Court.
I'm
That has been dismissed on
Filing-
18/7/2025.
seeking for 2 months, times 8 weeks time, my Lord.
Lordship,
But
kind
that should be before the original court,
But-
not contempt court.
My Lord, I'm praying for some time. Lordship may give me
Lordship kindly mark the date 18/7/2025.
8 weeks time
Dismiss,
to
ma'am.
implement your Lordship, sir. No. My Lord,
If he agrees, we will record your undertaking at the most. And in the event that is not followed, that will be aggravated contempt.
Obviously.
Do you agree?
No, my lord.
You do not agree.
No, my lord. I object. My lord,
Comply with the order.
1 year before they have approached the Honorable Supreme Court. This means.
Yes, that is after.
Advocacy is also important.
Yes.
Not only knowledge of law. Now he is saying, we will implement this order within 8 weeks. In the event if they do not do, that you can argue, there your advocacy begins,
Yes, ma'am.
skill of advocacy begins.
Yes, ma'am.
So in the event they do not do, then the officer shall pay rupees 5,000 per day.
So my lord, two cases are there simultaneously. In one case, the time is extended. So both the cases will be implemented. What I was.
10,000 per day. 5 plus 5.
My lord,
No, that is not
my lord, no, they will implement it. But may not things that cost.
No, that we are very particular. Cost will be fixed, will be recovered from the official concern. And an entry will be made in the service register so that he should not gain a good position in the career progression.
What should be simply. No, no, my lord, but I was told that within 8 weeks they will implement it.
That we will write. We will add our clause also.
Yes.
Default clause. Right now. This complaint alleges violation of coordinate bench order dated, judgment dated 8/7/2025, entered is complainant writ appeal number 2629 of, no, not complainant, in the state's writ appeal number 26. uh, 10 days and 10,000 rupees for the days next following. Okay. Individually, separate order. Huh? That in judgment, you have to see that, which is that judgment. Give SLP number and the date of dismissal.
Already.
Naturally relating to the industrial dispute and rules. The fact of the case is like this manner, 3 to 4 read petition are involved. So that I am to clear before the honorable court that there is a Madhurnagar power loom unit is.
Same counsel.
So after you argue, you make that observation because Supreme Court is binding on us. And
Small finance, one small.
That does not small judgment of Supreme Court, is not that much.
I'm not there, but what is small finance? Already
You have to
advocated.
record because we can't avoid.
I know one line.
Certainly you have to listen, then you can understand. By speaking, you can't understand. What I'm saying to you.
To examine the case of the Supreme Court.
What regarding what?
Regarding the similar case.
No.
Not follows. And I could follow that. So Mr. Parikh argued the matter.
My associate, my senior matter.
So who argued the matter?
I think.
Whether he is senior to junior is not have been discussed. That's not the point. The point is that Supreme Court has specificated in strong words that you to be argued by another counsel. So whatever, who has argued, please argue that. Because
All the cases I have.
senior is not recorded.
My name is recorded. Read petition as well as.
In the order.
I am a permitted one.
Then you have to answer that. Yes, I argued, but my claim doesn't find place. Or
I'm sorry.
sorry, there's nothing to smile or laugh at. It's serious. Kindly ask the appealant, if Vasudev Parikh SK Das, you are not on recording, much less you argued the matter.
The read petition will go through.
That's the problem.
Review it another.
So don't do that. Don't do that, let him argue, have confidence in your children from well training. So you rate that judgment.
And that does.
So kindly read it, write it out. And your age and experience.
Yes, case is just small different. For that reason, I want to satisfy.
Sir, we are at the threshold that another council has been the review application other than the writ petitioner.
The read petition I have to find out because in the review I just filed in the name of Astapari. So, but I pray to argue the matter, whether the matter will settle here. Where everything has been compliant.
Your name is there.
And
You are not on record, your name is there. So, big application. You know how to use the paper, the system. So this is the transmission. Take care of local. Just open the read petition. Go to the local.
Answer.
Your name is there.
You have got signed off now.
But you have argued the matter.
But you have argued the matter, it's evident from the. From the 16.
Yes.
You signed actually. I just wanted to show you that whether you have signed and where mistake.
I'm sorry.
No. Sir, you are taking it all the way. That is,
That's right.
it could be a issue. You never know the other side.
One office may associate with the last
Yes, sir.
more than 15 years.
We have understood.
What is the point?
What is very simple manner already adjudicated, nothing to more argument is there. What happens, my lord, there is a my lord, for a order dated, my lord, tribunal's order. A lay of proceeding was challenged before the industrial tribunal, and tribunal is a finding, my lord, phase 22, 23. The finding even phase 22 of the revision. The last part I am only saying. I am inclined to read petition, my lord, 30347.
I'm inclined to
I am
hold.
inclined to hold that the laying of a 234 workmen, that involved 234 workmen, as per the list imposed in the order of the reference with effect from 1 to
Held to
1984.
be illegal.
Yes, my lord, they are directed to illegal, and therefore, in view that the workmen who had been laid off with 1 for 1984, and subsequently,
Again, I'm attention to the court.
my
So, by which part of the order which you are seeking review, because review is very limited. So can you read paragraph 6 of the order which you are seeking review?
prior to that,
But you have gone to the tribunal's order. And that should say that you can't hear the challenge.
para 6, my lord, is 9.
Page 2. Internal page 2 on the,
Implement
page 2 of the order, para 6.
para 6, my
You
lord.
are seeking review.
I am placing matter para 6. Having heard the London Council for the parties and after going through the record, this court find that the members of the petitioner union workmen the unity under the closure, and as such they are entitled to get some compensation. Consecutor and official liquidator was appointed for liquidation of such society, who is at the helm the affairs of the resolving the dispute among the parties, mostly the employees of the industry under liquidation. As per the claim made by the employee, the amount was sanctioned and disbursed in favor of 68 employees amounting 9,75,000 so. Though there are other employees, there are neither applied their share nor claimed such benefit before the official liquidator. Therefore, the balance amount is lying with the liquidator to be disbursed in favor of the workmen. But in the filing of the introductory application before the court, in the earlier read petition, 23 workmen have been claimed in such benefit, which this court has already disposed of as the declining the relief as claimed by them, as they are the simple fence liquor. Taking into consideration of such observation made by this court. The court.
That on your order, it was followed by this court, but then challenge before the Supreme Court.
No, madam. So we are at the age of 85, 84, like this, 238 workers. No, I have not challenged. I have not.
Once you fill in the other second application and followed it.
No, madam, here, Here in the present interpretation, my only player.
Sir,
No, I have not challenged. I'm not challenged.
how can the second division things into earlier division?
That I'm saying, madam. That I'm to clarify.
Right now, find the
Second,
Find the review of the first case.
no, first case, second case, madam. 3034.
Why did not earlier that?
For that reason, I'm clarifying. I may permit to clarify. The clarify, I have not filed in first order, I have not challenged. Award, my lord.
When we find that the award is in vain,
We are directed to grant their reinstatement with that.
Why can't you move a review petition even in that, along with this matter? You file, what can you file? We are not suggesting, we are thinking aloud. There is scope for filing review petitions in the other matter. So that matter and this matter can be taken together. Think about that.
Small permission may be better. As interpretation, 23 employees are, they are simply settled declared by the court. Now, before this report 92, 93. My response submission matter, only one line matter. Amount already recovered 22 lakhs. 9 lakh disbursed. Now, say 68% already paid. Balance person are there. They are now at the age of 90, 88, 9, like this matter. Even they are not coming to the court, not contact with your spouse matter. Like this position. They are in the bed of a matter, death like this matter. Only my response submission matter. The rest amount may be released in favor of the balance people.
what is the aspect that the actual beneficiary get the money?
Yes.
Most likely, the earlier division bench, which is in, which, the subsequent bench has referred. Kindly mark that, please.
পয়সা পাই যাবেন
274 of 2002.
Yes.
So this was the offer, 71, 2020.
2010.
নাই মানে
2010, that's a tabulate.
Yes.
2010.
My lord, it is 25/1/2012. The miscase was
মিসকেস পাই
And JC number 2674 of 2002.
yes.
It was disposed of by order dated.
It was disposed of on
And the IA order is the most important. That is the IA 2018.
what was it?
25 1
71, where it is mentioned as 7120.
No.
last parade there.
So 712020 order have you have said.
In that order.
So it was annexed to the writ application. To the page.
No, I do not have.
7071 complete or I have next man. IA and
Sir, can you tell the name of the page or whatever, sir? So we can look at, another look at that.
is 32. What the 7121. Well, that is confined to 23%. They approve before this one, honorable court. Then it is a simple settle.
And you were not parties to this,
My lord.
you were not.
Just check it also.
Kindly place that, sir. You could have that.
They cannot challenge the They are not parties to. You are the parties to this OJC.
Yes, yes.
Then you have to file a review in that also to them.
And that is confined to 3%. Here 92.
So 23%, you were parties here. Huh? But that operates as.
Since it is the industrial forum, my lord knows it very well. For interest of justice, my lord can pass order to the amount already collected, only required to disperse.
The OL
See
has
the only-
collected the amount now.
That is the 13 lakhs like this and 92%.
Yeah, approach the OL refuse. If they approach with identity, because now there is the issue, because it is not in name. So we do not know.
The name I have given, my lord.
Even is not, can they receive that amount?
No, the 92% not received, 68% are only
So
received.
whoever wants to receive, can they receive directly from the OL? If possible.
And from the
Because now this.
official liquidator.
This idea notice you are party there.
My lord.
You approach, after disposal, you file a ID. It was disposed of on 25/1/2012.
Again.
After, I mean, quite a long time you filed the ID. The highway was considered and this is the observation.
I don't know. My lord, may one thing, my lord,
How can it get? Should have.
some outsiders are there.
It's a- Try to look at the order so that you can make a proper submission. Sir, look at that. There is that. Bill 39, may I assist you, Mr. Achal? My bill is taking a lot of time. The idea that this was taken up on 25/1/2012. In that view of the matter, it is ordered that official liquidator of number 2 shall invite claims for the employees. From the employees are asked to power to Cooperative Cooperative Society Limited and shall distribute the amount realized from the sale of the machinery to 22 lakhs among the employees following due procedures. In this matter, after 2 weeks, one of the valuation reports became to the members. The official liquidators will apprise the court about the development of the case on that date. When the case was taken up for hearing on 18/5/2013, was the bench of this court passed the following order. Another bench, in fact, that was maybe the second. Since the employees have already filed their respective statements of claim before the official liquidator and their claim is much more than the amount available with the official liquidator, this court directs the official liquidator disburse the claim amount to the employees proportionately after calculating the same within a period of 4 weeks from the date of production of certified copy of this order. Make clear that when disbursing the claim amounts, the official liquidator shall deduct the cost of the unpaid published in respect of the amount claimed in it. At that stage, did you file your case?
After the 18/3,
Apparently, the case was again adjourned on 25/4/13. In the meantime, petition in Ms. K. Swanso was filed by the official liquidator for modification of the order stating that as he has incurred expenses for violation again, the doing that tax not pertaining to him.
Concern from OL, whether you have received the money. If he has received the money and does not disperse, then he has no right to retain them, regardless of arguable legal principles. If money of these people is lying, for ascertaining whether OL has received that money and distributed it to UP. If he says we have done, that is one thing. He may also say we will not do because these are the legal principles. So that we will issue notice there.
Yes.
Huh? Third,
fixing the date.
we can't fix date because it's a review petition. It has to come. Yes, ma'am.
Better if we stay on record.
Yes,
Because now you also do not know what the official liquidator, I mean, got claims from whom, to whom he has paid. Who are these people?
From his records, he will say. Heard learned counsel Mr. Acharya paid for the review petition. First, a prima facie case is made for issuance of notice in as much as the essential grievance of the review petitioners who are in the evening of their lives complaining that though the official liquidator has received the amount from the management, the same has not been ratably distributed to the workers. Workmen who are the review people, who happens to be his friends, who happen to be common, although others appear to have been paid. But this aspect can be asserted from the say of official liquidator. The industrial company being in liquidation.
So made the OLA party in the review.
Review, yes, I do.
Or just now by oral prayer, you make him a party and take notice. You have to make oral prayer, not say.
Well, the document, I mentioned proceed from industrial company. Mr. G, we will say that the OL to be made a party.
Yes, already made.
He made a party. Mr. G, on our request, accepts notice for the OL. Whether they have
They are to, they-
operated.
yes.
Issue the Muslim notice to OL. Mr. G, run a report.
And only gentleman or Krishna, there are the official liquidator, the name only want to change.
No, we'll say official liquidator.
Yes, sir.
We will not say it is by designation, na? Persona designator. Still matter lies in a narrow compass and petitioners are in the declining gate. Come on, push this matter immediately after service. Maybe 1346. Yes, sir. That 23rd.
Attorney make a mention of it.
Huh.
Well, it's a
Fine.
late appeal minute. Learned single judge added to consider my representation in light of a judgment with a judgment minute which has been confirmed by the apex court. But against that order, my lord, status shall.
Last week.
Lord, may I mention a memo, my lord,
Right.
for listing, my lords? But in this case, my lord, the petitioner has made all the payments, but the opposite party, Bank of Baroda, has not issued the sale certificate and neither issuing the position, my lord, transferring the position, my lord.
I'm a part
But-
of the mention, your lordship. Your lordship, direction on 8/5/2026, your lordship, after someone with this immediately list this matter. This is a pensionary benefit, your
Last
lordship.
week of.
I beg your pardon, your lordship. The pensionary benefits of the respondent has been stopped by this rate appeal, your lordship. May kindly be lifted to more.
I beg your pardon, Your Lordship. It's a rate appeal matter, Lordship. The neem tree is situated just adjacent to the boundary of the petitioner's wall. So since it is a growing tree, by width also it is growing and it is demolishing the boundary of the petitioner. So Your Lordship, for a kind consideration.
I understand that, but where is the urgency? Tree grows not like men.
It is
Very
demolishing
slowly.
the boundary of the petitioner, Your Lordship.
Yes, the first week of August.
My lord, one rate appeal, my lord, it was listed on 19th of June and it was adjourned to a week after and then postponed.
May I please, Lordship? Yes. I came before Lordship against the order of the Government Central Tribunal Court of Appeals, Lordship. Dated 26/2/2026, page 66, Lordship.
MACP scheme.
Yes, Lordship. What happened, Lordship?
Modified
Assured career progression.
assured career progress.
Progression, Lordship. What happened, Lordship? He was joined in 1983, Lordship. And retired in 2019. The junior persons has filed, given the higher benefits, Lordship, in view of the Hon'Ble Apex Court judgment, Lordship. And
Not extended to you.
not, no, yes, Lordship. What happened in the same, Lordship? Thereafter, the department in 2021 extended the benefit,
Letter withdrawing.
given the benefits, higher benefits, that is the 5 lakhs or more, but less than 72,000, because of which was given in earlier 2013, that is MACP 3, that is withdrawn. I came without giving me notice, that has been withdrawn.
Scheme itself is
No.
money is
My MACP 3 is withdrawn without giving me notice.
But you were given the benefit under that other scheme.
Other
On the basis of the direction issued by the Apex.
Yes, Lordship. But which has been given in MACP 2, that has been withdrawn.
But you can't have both the benefit.
Because of why I have come before Lordship, they have said that with the
chance before other bench. This bench is against you.
no, Your Lordship kindly why I am put before Lordship, Your Lordship kindly see page 71. Paragraph 6, that is the 71 operating part, Your Lordship. Page 6, last paragraph, 3 lines. According to the Law and Counsel for the applicant, since the withdrawal was without giving him notice opportunity, the same is bad in law is concerned, we may record. Where
That is there, but another
That's there.
alternate
That is
benefit
there.
you have taken.
No, sir. Sir, what happened, Your Lordship? TBOP is the TBOP has given the to me, that the financial benefit, Your Lordship. BCR also financial benefit, Your Lordship.
Correct, in lieu of this, you have taken other benefit. There is nothing.
Only grievance is this, that you have not been given an opportunity of heart before withdrawing that.
That's it. How it will improve your.
Improve, Your Lordship, because they have been counter, they have said.
No, see the reasoning which has been given
Yes,
by
Your
the
Lordship.
tribunal
Yes.
is that probably that will be the final order.
Yes,
That is how they have not been given.
Yes, what happened, Your Lordship? Because
Next.
The matter where the petitioner has paid for regularization of the accounts which has been taken, the loan has been taken by the petitioner, and it is the agricultural land has been given mortgage, but the bank has proceeded against the agricultural land on section under the surface area, it cannot pass.
But cannot mean, suppose at the time of taking loan,
Yes, ma'am.
you give impression to the bank that it is not an agricultural.
No, it has been reflected in the notice, my lord. I have,
You offered that.
no, my lord.
You did not offer it.
Two lands I have offered. They have, both lands they have stated in the notice. They should not. But I want to square up the loan. If some time is given by the bank, I have given the reply on 13 PA stating that I will square up loan, or I
What is
want
the loan amount?
a loan in view of the notice, my lord.
33 will not come to your aid. The
33,
law cannot be used as an instrument of fraud.
I have given not fraud. They cannot proceed against the agricultural land, they can file suit against the agricultural land. My homestead land is there. They can proceed against.
You have given mortgage of that.
Yes, ma'am.
And
Once
mortgage,
having given,
I am not
say.
I don't want to
Mortgage
enter into
has
this.
been
I want to square up the loan because my home is there.
What is the loan amount?
Your lordship may see. And notice dated, it is now. 89, and another is 28.228, my lord. Total near about 90 lakhs somewhat, my lord.
What?
Two loans. Only 28,000, another
28,000.
only. He is repaying.
You pay 30% of the amount now,
Yes, ma'am.
within 2 weeks.
Yes, ma'am.
Okay?
Yes, ma'am.
Heard, Government Council appearing for the petitioner, moreover. First, very many points are advanced, including one under section 33 of the Surface Act 2002, which exempts agricultural land from being mortgaged or encumbered for securing the repayment of loans. First, he very fairly submits that he is ready and willing to settle the entire outstanding after having a conference with the lender agency, of course, in accordance with the rules of the extent RBI guidelines. First one. Next paragraph. Counsel for the petitioner draws our attention to A number 11415 of 2026, supported by an affidavit, wherein some urgency for securing protection is made out. First, in the above circumstances, the said application having been favored, coercive proceedings are halted till the next date of hearing, subject to petitioner depositing with the bank 1/3 of the outstanding amount as on this date, within 2 equalized weekly installments, failing which the not only interim protection withers away, but the petition itself runs the risk of dismissal on that ground alone. Next. Disposal of this program.
Because is pending before the loan, we have to contact my loan.
Short grievance of the petitioner herein is against the long pendency of the subject essays on the file of debt recovery tribunal cutter. First of all, counsel for the petitioners. Right to speedy justice being one of the facets of Article 21 of the Constitution of India in the light of pattern of decisions of the apex court, the essays cannot be kept lingering on the file indefinitely. First, we agree with this. Next one. In more or less similar matters, we have declined to issue any notice to the other side, since it will have full participation before the DRT when the essays are taken up for consideration. First, in the above circumstances, we request the learned presiding officer of the DRT to hear and dispose of the subject essays, preferably within an outer limit of how long they have been pending now?
It is 25, since 25 months.
Within 4 months. Within 4 months. All contentions of the parties having been kept to the registry to send a copy of this order to the OP by speed post.
All these 4 matters are like that.
How much?
Same order.
May I please, Lordship? May I please, Lordship?
Yes, sir.
So kind permission. This is the Milord I want to square up this is my residential house there. We all the Milord quarrier and also guarantor before Lordship. And disbursed amount was 2 crore 80 lakhs for the hotel purpose of my husband.
2 crore 80 lakhs.
Milord disbursed sanction was 4 crore 70, but disbursed 2 crore 80. When Milord NP was there, 2 crore 98 lakhs.
When it was?
Now, Milord 2022. Now the amount is 3 crore 90, about 4 crore, Milord. About 4 crore. And I have paid already 1.5 crore, but without, I want Milord mercy, because I want to secure my property, Lordship.
Mercy is not money.
Money.
Money has to be, when money is taken, it has to
I'll
be.
money, I'll
I've seen a story of philosophy by Will Durant, wherein he gives a life story of Socrates. Socrates had borrowed 1 hen, and when he was dying after consuming the hemlock poison, he said, he told his disciples, I had borrowed 1 hen from Mr. Epicure. Therefore, you return it as my fees for the tuition which I had given to you. The dying man repaid it, then he closed his eyes. Therefore, when you have borrowed money, you have to repay. You are not repaid. Therefore, court cannot help you. You agree? Then we'll dismiss this petition. How much 4 crore is outstanding?
4 crore outstanding. They have Milord auction, but property is in my position.
They have auctioned the
Yes,
property.
but-
When auction took place?
Auction took place in the month of May 2026.
Then go before the DRT. Still you have time. We will observe. Borrowers are knocking at the doors of Red Court, complaining against the coercive measures of recovery, the subject security properties having been auctioned in May 2026.
Milord, 25, sir.
May 2025. Then what can be done now? Because of our judgment, it is only 90 days or what? 45 days. Anyway, you take up that contention.
I will also protect.
First, learned counsel for the petitioner having submitted various points of law. Now agrees with the suggestion of this court that his client should seek redressal at the hands of the DRT as provided under section 17 of the Surface Act 2002. First, he has also mentioned about the limitation period prescribed by law for availing such a remedy, which aspect the tribunal itself has to consider a bit leniently if grounds do exist there. First, in the above circumstances, this petition is disposed of, keeping open all contentions of the party. First, it is open to the petitioners to seek interim relief at the hands of the tribunal if grounds do exist there.
Protect me.
Yeah,
Protect me. Protect me.
No, this is, you should make application before.
Milord, because Milord now.
We cannot interfere.
But
We have a bit gone astray of the law.
Because of the residential house, only for 2 weeks.
Nothing can be done. Yes.
In order sheet, it is mentioned, contact number.
Typographical error to be rectified as indicated in the any application you have made. Well, office is the office in that maybe registry. The office as for the office.
But it's a matter of.
Contact number is 3744 of 2025.
But it's a matter of regret, my lord, in spite of lordship's direction, my lord. They have not yet complied, my lord. So since the date of 11/3/26, your lordship directed to pay the compensation.
My lord, we are ready with the money. Money is with us. The legal error dispute has dropped.
In spite of.
Legal error dispute.
We have submitted.
Who
all
are the original legal errors? That is the legal error dispute. Therefore, we are unable to pay to the appropriate legal error. He may cooperate with the process we are having with money. Lordship may observe that.
We have submitted all the documents, my lord, since last one.
Documents you have given.
Since last one.
What are the documents you have given?
Documents, legal error certificate.
Give that. Show that to us.
I have not having, my lord. We have submitted before the authority, my lord, since last
He
one.
himself was discussing with me yesterday only, my lord. And I have ensured that there is a legal error dispute. Your lordship may direct them to cooperate. And we will, within 15 days, we'll sort out the matter.
We will cooperate, my lord, but they have stated, my lord, all the persons.
Your client is here behind.
All the persons should appear before the.
Your client is here. You are arguing for the court or for your client? He is saying, we are going to do the job, provided you produce the necessary.
We have already cooperated, my lord. We have submitted all the documents, all the paraphernalia.
We are not there to.
You accept notice.
Yes.
You accept notice, then let us see. Let it may take another year hereafter. Therefore, instead of that, why can't you use your advocacy skills? Anyway, issue. We'll issue police notice.
That your lordship usually do, but your lordship may dispose of the matter, granting us 3 weeks time.
For what?
For the settlement.
But you will say a dispute is there.
No, he is to cooperate.
They have stated all the persons should appear before the sub-register for registration, my lord, without provision of law. Is it possible, my lord, all the beneficiaries?
And then produce that when we are accepted direct.
They have stated, my client, all
Without
the
document submitting.
all the basic beneficiaries should remain
cannot
present
go-
before sub-register for registration. But it's a matter of all the
You
beneficiaries.
should permit us, no? You will not permit. You take notice, let us see. You try your pleadings.
Yes, yes.
issue police notice. First one, in addition to usual service, on your request, Mr. Hon'Ble, the DG accepts notice for the containers, subject to authorization. Okay. Next, 23.
Item 6, content 3021 of 2026.
Is your lordship, my lord, the lordship has directed to approve the appointment of the petitioner since 12/6/1992 and to confer all service benefits to him within 8
Will
weeks
issue
at the
notice.
outer limit.
Will issue notice.
My lord, they have filed an
Already passed an order, your lordship, dated 34/2026, your lordship.
Say-
Pursuant to your lordship.
Saying you have implemented the order.
Yes, your lordship, we have said that the governing body, we give instruction that to approve the appointment of the petitioner against the post of storekeeper in zoology in AB College, Vasudevpur, as approved by the governing body of the college at the initial stage with all service benefits. The governing body, being the employer of the petitioner, shall make payment of the salary as due and admissible to the post from their own funds, as no sanction from government for the same was obtained. As such, the governing body is liable to meet the salary contingencies to the petitioner against the post with effect. Such appointment, that is from 12/6/1992 onwards till the date preceding the date of approval of such appointment by the government.
What action you have taken for ensuring that the government, the governing body will abide by your order? You can't say, I'll pass order and I'll sleep. That is not good governance. You have said the governing body should make the payment to him.
Apart from that also.
Apart from this, you have to keep quiet because what is in your favor? Or you want to pollute that?
No.
Then keep quiet. Madam, you have passed an order. Passing order is one thing. Money reaching hands of the litigant is another. What steps you have taken for implementing your order? Because this order is pursuant to our direction.
Yes, your lordship.
Passing order is useless. Implementation is the factor. What steps you have taken for implementing that order against the management?
Lordship, I give-
Again, one more case will come.
Your
We
lordship.
will be wasting our time like this only in chastising the government officials.
He gave
Next
us-
step you have to say,
Yes, your lordship.
issue emergency notice, learned agent. Served. Anyway, now madam is appearing now. The notice, police notice was ordered on such and such date.
22/6/2026 was
Issued. First, however, for want of requisites, notice did not leave the premises of the court. First, let it that as it to be as it is. Now let the AGA madam accepts notice for the contemners and draws our attention to the order dated
34/2026, your lordship.
34/20/2026, wherein a direction has been issued to the management to make the payment of the consequential benefits, financial benefits, pursuant to approval of the position with effect from the initial entry date itself. First off, the contemners to apprise the court as to what steps have been taken for implementing the order in question without driving the complainant to another round of litigation avoided. First off, for that purpose, some period needs to be granted as sought for. First off, text in the circumstances, call this matter on in the first week of August. Yeah? For August, 4/8. And so for reporting compliance, the enforcement of the subject order for the management. Okay.
Pardon me, Lord, item number 5, that was the disposed of matter. Your Lordship have observed that on revival, your Lordship have issued notice. On revival.
Heard on the prayer for the wife.
No, I am not praying at his instance.
No. Their prayer on the wife. Yes. Got it. Thank you. Yeah.
Item 7, content 3070.
We issued notices today in the item number 8.
my friend had submitted an affidavit saying that they have approved the Honorable Apex Court today, yesterday, filing a diary number. My submission is that this can't be the way to avoid the implementation of your lordship's order.
Give some short date.
Yes.
If nothing happens, then we'll implement the order.
Only I pray next week.
Not next
23 is the order, my lord. 2023.
23 is the order.
Yes, 4th of February, your lordship disposed of the writ appeal. And writ appeal was filed after delay of 548 days. Now, some of them have also retired in the meantime.
Now, SLP is filed on which date?
Yesterday, my lord. 1/7.
Then virtually what he says appears to be true. Was it within limitation?
No.
My lords, it will open and.
Only to avoid this court, the government is doing. Of course, it is your right to fight the battle. We cannot come in. But unless you obtain the.
My lord, so what I'll pray, since it was filed yesterday, your lordship may grant 3 weeks time, at least 13th it will reopen. We'll try to.
Police notice, let your clients come and say.
Notices have all, your lordship issued notices.
Yes,
Notice is heard now.
Yes, they have filed affidavit.
Affidavit saying.
No. Noting is that instead of filing requisite for issuance of police notice on OP 126, the petitioner advocate filed requisites. So, my lords, it may not have issued, my lords.
You have filed a reply also now?
Yes.
No, we have filed.
We have filed, your lordship, because
Then what is the notice? Postman did not wear his
No, my lord.
filed a show cause stating that we are contemplating of filing an SLP, your lordship, on that date. But yesterday the SLPs have been filed.
Correct. After the service of notice.
That was intimated by our office, your lordship,
Correct.
in response to that.
Right thing. But righteous thing would be to implement the order. Otherwise, but this is only to avoid this bench doing. I do not really know what will happen to the contempt law after some time. Really, I'm very sorry to say this.
Similar matters, your lordship.
8-9 matters today. I pray that your lordship may observe that we'll abide by your lordship's order conditionally subject to the outcome of that.
That's what.
That's subject to the outcome of the SL.
Yes.
That your lordship.
No, not observing. You only have to do that.
Oh, I the affidavit.
Now we have filed affidavit saying that we have filed SLP and we'll stick.
Your lordship, the Honorable Apex Court will open on the 13th, your lordship. So 3 weeks time may be
Which day is in miscellaneous day?
reasonable time, your lordship, to present a case before the
Which day is in miscellaneous day, my lord?
88, Madam and Vibra submit that against the orders whose violation is complained of, SLP has been filed in the recent past, and that the Apex Court would reopen on 13th of July 2026. First up, they further submit that some accommodation may be granted to have the matter posted before the Apex Court. In the meanwhile, first we call this matter on 4/8. Yes, 4/8. 4/8 for reporting compliance, subject to outcome of the pending service.
Item number 18, 19, 20, and 21. All are same. SLP.
8, 9, 10, 11, my lords.
8, 9, 10, 11, then 18, 19.
18, 19, 20, and 21. Now, counsel for the petition is same. Mr. Misra is there.
Same order. They will help you, na? 18, 19?
18 is government. No. 19, 20, 21.
19,
20, 21.
Yes. Then 7, 8, 9.
7, 8, 9.
7, 8, 9.
10 and 11.
7 to 11. 19 to 21. Same orders. Yes.
It's a complex matter, And at this juncture, I don't feel that appropriate that your lordship should give much time in this matter. And because it will take another half an hour, minimum
In
half
this
an
case, what has happened, well, my contempt is not because the appeal is pending.
On 23rd, we have posted it. Yes.
Yeah, my client is interested for disposal of my loss.
Sometime I wouldn't want to kill your lordship's precious time at this juncture. my lord.
Yes, in this matter, your lordship has issued notice. On the last occasion, they didn't appear, and your lordship directed that notice which shall be deemed to have been made sufficient. So on merit, I am facing the fact matter.
No, on merit, we are not taken because we are hard pressed for time. We have some few matters which you have posted on special request. A lawyer from Calcutta is here, another lawyer from Delhi is here. Therefore,
Only point is whether, in case of delayed payment of gratuity, I will get,
interest to be paid or not in the point.
whether I will get 10% or 6%. That is the only point.
That is yes. Yes.
Yes, senior advocate Vijay Kumar Das will be appealing this case. It is not well.
9th October 2005, let us 25 compulsory retirement cost. In the guise of this rate appeal, my lord, they are not allowing me to join. Only any
Date we have 24.
yes. Can I pray next week, my lord? No. As a special case, my lord.
Possible. Next week, how many days will it?
Because this man is about to retire in October, my lord.
What will happen? 24th, we are putting the matters. July 24th. Yes. Yes, for the appellate. Or in the first week of August. Next.
Millard, it's empirical.
Similar matters, how you
Yeah, in similar matter, both the matters before vacation, your lordship kept for interim orders. But immediately before vacation, the first matter they mentioned, this is order your lordship have passed. So
who appears for the other side?
Other side, Mr. Pagi.
My lord, I am appearing in item number 16 in the same matter.
Sir, we have made some orders, interim orders. We
Interim
took
order
it
in
interim orders because similar matters.
Absolutely.
Third.
Lordship, I'm appearing for respond number 2 in this matter for Bureau of Energy Efficiency.
Anybody on caveat?
No.
Nobody on caveat?
All no.
I am appealing for opposite but no 4.
After notice. This is post notice matter.
Yes, my lord. So it's a kept it for that. Interim order will be passed after notice is given there.
Now the present interim order will continue and on 10th of August we will take up this. Interim order, heard Learned Counsel appearing for the parties. First of the interim order earlier granted shall continue.
In this case, there is no interim order. It is to be passed.
Both the matters are kept together for interim orders.
Exactly.
We are asking, is there interim order?
Yes, my lord. In my matter, yes. On the last date, my lord, your lordships have passed an interim order.
There is
so simple.
There is an ad interim order.
That's what.
Then ad interim order, but not this order. The lordship passed the other day.
The interim order.
My lord, may I make just one submission, my lord?
Calling the first week of August 15. Next.
My lord, the interim order passed in my matter to continue. My lord, may I make, if my lord friend allows. My lord, the order passed, interim order in my matter, item number 16 is continuing, my lord. I couldn't.
Yes.
Yes. Till the next day.
But same order in my case. Same order.
Whatever order is there, that continues till next date of hearing. On that day, we consider all submission. Next.
Item 15. Just now, 15.
We are filing reply to the regional counter, madam. Today, madam.
You are filing the counter.
Reply to the counter, madam.
Reply to the counter. Counsel for the appellant seeks leave to file the counter. Reply to the counter. First of leave granted. Granted. Call this matter after 3 weeks.
My interim order, my candidate.
They have interim order. Interim order. 4 weeks. Interim order to continue.
Obliged.
Till there.
It's submitted, man.
Huh?
Submitted.
No, interim order is there, na? You are for a proceeding. Okay. And in the first week, second week of August.
Obliged, ma'am. Wait, please. When my learned senior has filed the I have filed 2 review petitions against the judgment methods. The review petitions are the tag matters, second and third matters.
Yeah.
May I take your lordship's attention to review petition number 99, the third matter.
After 2 weeks.
The pendency
We have
of
no
the
time there.
the pendency of the review
First
petition.
week of 2020, August 20. Next.
The review passed by this.
I will not decide.
Your lordship's order.
Correct, but I will not decide. I am telling you. It will come before the other bench.
Lord, we have no time.
No time for that reason. Otherwise, happily I would have decided.
But only one thing. There is series of judgment. Pendency of a review petition
No.
is no bar to implement the order. Here, the doctors were selected for the advertisement in 1718. Candidates securing less mark have been appointed. Your lordship expressed the concern. How?
July.
23rd of July.
July. Next. Yeah. 12.
In this one, we come to 18. Item 18 is confirmed. Most cases were we want to go to chamber.
Item 18.
Just now they have.
Yesterday only we have filed the show cause, taking the similar plea that we had filed SLP yesterday. My lord, your lordship grant us the similar order.
4 months.
That was
of
that.
Your lordship order.
SLP is fine.
SLP file.
For some
That
retired
grant we have
person
Same order.
not getting
Whatever we have.
subject to outcome.
Same order. For reporting complaints.
Yes.
Okay. On which date we will put the content?
4-8.
4-8. Okay. Come back. We'll come back in a couple of seconds. With the
I'll try to be a little quick.
yesterday you argued on the culpable conduct of.
Yes, I was on the NCLT order last. I'll just start with that 2 paragraphs and then I'll move on.
Yeah.
Would your lordships kindly see PDF page 357. Only 3 paragraphs, not 71, 72 and 83.
We note that.
Yeah, we note that.
This you have read yesterday.
I have not read. Did I?
This you have read.
No, I was reading the conclusions.
Oh.
He notes the financial director, Natkani contractors and the corporate data belong to the same group of companies, which has been shown through 2 charts presented by the senior counsel for HIL and which are reproduced in this judgment earlier. We also note that a request for urgent hearing was made. But this is a little important. We also note that a request for urgent hearing was made by the counsels for the corporate return
and the purported financial creditor Nandkani, when the auction, I told your lordship that as the assets were to be auctioned, they went there and stalled everything. So this is what the NCLAT is recording with. We also know that the request for urgent hearing was made by the counsels for the corporate debtor and the purported financial creditor Nandkani when the auction of the corporate debtor's assets had become imminent upon the orders of the Honorable High Court of Orissa. After such a joint request was made to the adjudicating authority for urgent hearing, we know that the hearing took place immediately thereafter and the admission order was passed with inexplicable speed and alacrity when the adjudicating authority does not even appear to have undertaken a proper scrutiny of the necessary examination under 7. So that's the point I was trying to make. Because auction was imminent, now they go and move there. One more paragraph, my lords. Para 72. On the basis of the aforesaid discussion regarding issues 1 and 2, we are convinced that Section 7 application was submitted by Nandkani contractors fraudulently in collusion with the corporate debtor to seek an admission order of CIRP of the corporate debtor, and as such, the admission order was given by the adjudicating authority without proper and adequate scrutiny, etc. Now, one more paragraph, and then I'm done with this document. Kindly see, my lords, page 83, para 83. 363, para 83. PDF, my lords, page 363. Once we pierce the corporate bill of the companies involved in this matter, the element of fraud played by the creditors of the corporate debtor, starting with collusion between the creditor and corporate debtor, becomes apparent. Fraud. The spirit of the IBC has enshrined in its in stating the body reasons are for balancing acts, etc., etc. Any action which militates against such spirit is bound to raise serious doubt about the CIRP and should be looked into deeply, examining the element of fraud or gaming. Therefore, in our view, gaming means fraud, playing games. Therefore, in our view, any abuse of the provisions of IBC to fulfill the ulterior motive and business interest of the very harsh words of certain parties to the detriment of certain other parties, such as workmen of the corporate debtor, HIW Workers Union, and my lord, HIL is me. I was using this side, HIL, should not be allowed to happen. Piercing the corporate bill to infer the conduct of the company should therefore be seen in this context. But I am done with this document. Would your lordships now see, minutes, some of the orders of your lordship's court, and they are 3-4 orders, minute. The first one is at 223 PDF. Just quickly run through, just in 2-3 minutes. Where all that I am trying to show is orders after orders which were passed by this honorable court were not carried out by them. Not one, several. If your lordships want, Lord, I'll read them. If your lordships want, I'll give it in my written note, whichever way your lordship. I'll do that. Now let us see, my lord, kindly come to the rejoinder filed by my learned friend's client before this honorable single judge. Let us see what they say about this. When we place it on record, your lordship may see there's a rejoinder filed in 2025. Not just to avoid, just to save time, I've tried to Xerox them so that your lordship don't search here and there. Your lordship may see, give a copy. Your lordship may see, my lords, you have it over. Kindly see, my lord, para 16 at page 5, just 4 lines and I'm done. My lord, your lordship may note, this rejoinder was filed on 17th of February 2025. And my lords, by that time, the NCLAT order had already been passed. Right?
NCLAT was there, but Apex Court order was not.
Apex Court order was also there.
No, this is 17 to 2025.
Yes.
And Apex Court order was passed.
This was filed on 17th of February 2025. And when was the Apex Court order? August 2023. With the same diary number, my lord, we have passed on the orders. So what is said is, paragraph 16, I say the petitioners have preferred an appeal from the judgment dated 9/1/23, being diary number so and so, and the same is still pending. Even though, my lords,
it was not pending.
By that time,
it
has been dismissed. And that order I am given your lordships. By a memo, my lords, I have given that order. So, my lord, the submission is. And in the second page, your lordships will see diary number 19069 of 2023. My lordships have it, my lord?
Yes.
And status is? Yes. So therefore, my lords, there was no full disclosure. As your lordships have always said, that, and my lord, the formal order your lordships will see is annexure 29 to the writ appeal. If your lordship sees annexure 29, it is 417 PDF. And my diary number, yes. At
328.
But give me half a second, Lord. I'm so sorry. It is HIW is at page 344.
Next one. About, let's say, 1, 2, 3, 4, 20.
Yes, 344. Diary number, my lord, is 19069. One 19069. It will be like
Page number?
Page number 344.
There is no 190.
It starts at 18657. Below there is a series of numbers. Below PDF 433. PDF 433.
433.
Again. PDF 433.
Oh, we are looking at 344.
And it will be 19th from the top.
Yes.
On the right hand side.
On the right hand side, my lords.
Yes. 19 on the right hand column.
Your lordships have it, my lords.
344.
344 and 19th from the top, my lords. On the right hand side column, it is 19069 of 2023. And the orders, your lordships will see, is at the bottom at
handwritten page number 380.
And that will be PDF and just go with PDF.
Yes.
My lord, 469 PDF.
It's 469.
Yes, 380 and 469 PDF. 469 PDF.
Please comment, assist.
Continue. Let Navneet go and do it, please.
Okay.
Your lordships have it, notes? Last paragraph, 4 weeks time is granted to cure the defects, failing which matter shall be deemed to have been dismissed without any further.
Yeah.
And the dismissal order, your lordships have seen in that memo.
Yeah.
So my submission to your lordship is.
That was not restored.
No. Not till now at least. No, this was.
Not yet. No prayer for restoration is made either. Restoration was made.
Yes. Prayer for restoration made, still pending. That is on instructions I submit.
Therefore, just we want.
Yes, I can file the memo which shows that it's there and it's pending.
You know, the case status as of yesterday shows it's not restored.
Instruction which the Delhi attorney has given to my local attorney, which I am.
So, my lord, my submission to your
Already
lordship.
restored also.
No.
Not restored.
Not restored.
Restoration sought for.
Restoration sought.
Now, my lord, this order was passed. This order was passed, my lords. So this was passed on 28th of August 2023. So we are almost close to 3 years.
At least, brother, do you have a date on which you have sought for restoration?
Yes, my lord, from the email which is at page 15, your lordship.
No, tell the date, just for our reference.
It's just same date.
When restoration was applied for?
Effective matters refiled after 90 days, 2011-2025, diary number 66824 of 2025.
Yes.
Now, there is a series of
Further
judgments.
instructions, on what is the current state.
There is a series of judgments, and I will not read them. I'll give the judgments and the paragraphs where your lordships have deprecated and said that if you have not come with full disclosure, you are not entitled to be heard in the matter. So that's my argument on conduct and maintainability, which has been brushed aside by the learned single judge, on the plea that these are diversionary tactics to move out from the main point, but that's another story. Now kindly see the fourth document I want to show you, lordships, is the counter filed by the railways before the learned single judge. It's an additional counter affidavit which has been filed by the railways before the learned single judge. And what I have done is, my lords, so that your lordships don't search and find and we waste time, I have made copies so that your lordships can straight away have it.
These are all part of the record.
Oh, yeah.
Just share a booklet with you.
Yeah. Everything has to be shared.
Yeah.
Well, I'm sharing. So your lordship may see, my lord, straight away come to page 3. Page 3, my lords.
In page 3.
Page 3 is the start. That's where the counter starts, my lords.
In page 3.
Yes. Of that small index. And my lord, your lordship may straight away come first to paragraph 5, which will be at page. Just find out where the 7. Paragraph 5, my lords, will be
Page 9.
Page 9. I'm grateful. This was the stand of the railways before the learned single judge. Kindly see, my lord, para 3 first, my lords.
Para 3?
Yes, it's a longish paragraph. That in response to the amendments made in para 1 of the consolidated petition, it is stated that in June 22, Hirar Joshi filed WPC number so and so. Kindly note, my lords, on behalf of petitioners number 1 and 2. Who is 1 and 2? One is HIW, and the other is at the other companies. Rigas.
Signatory.
Yes. So and Rigas. However, Dhiraj did not produce any documentary evidence like resolution passed by board of directors of both the companies, etc. My lords. In the website of Ministry of Corporate Affairs, Dhiraj Joshi is not appearing. Signatory of HIW and Rigas. Rigas is found to be a fraudulent exercise. Your lordships have seen all that, my lords. From the website of Ministry of Corporate Affairs, learn the registered address of Hirakud Industrial so and so. However, for the period 17 to 22, this is a little important. Because on the ground of natural justice, I have been suited before the learned single judge. You didn't follow natural justice. So what they are saying is, from 17 to 2022, OP number 1, that is railways, issued as many as 6 letters to the petitioner number 1, so at its head office, but all 6 letters have been returned by the office, factory closed, because nobody was there. They have abandoned that place and gone. Now the consolidated petition has been filed by Hirakud Industrial Works on so and so. Said petition has been signed by the learned advocate only in the said consolidated petition. Well, I don't want to go into technicalities, only to show 2 things. The site was closed, and kindly see para 5. That in response to the amendments made in 4E of the consolidated petition, it is to state, this is a little important, that in addition to the amendments made by the petitioner, the respondent number 1 wants to add some additional information to this point. In the siding agreement dated 28/9/2005, executed between East Coast Railways and HIW, so and so, the name of the respondent Hindalco Industries Hirakud as a co-user of the private siding. Right, minutes? In terms of clause 15B of the subject private siding agreement, Mrs. Hindalco Industries Limited is allowed to use the railway siding of Mrs. Hirakud Industrial Works dated so and so and full stop. The private siding agreement dated 28/9/2005 is still in force, for which Hindalco is entitled to use the private siding. This was the contention this was the railway which is not considered. That's the point. Now your lordship may kindly see para 7 over the page. That in response to the amendments made in para 4M of the consolidated petition, it is to state that the contention of the petitioner in para 4M is not correct, OP number 2 by letter dated 2/3/22 requested the OP number 3 to communicate the status of Hindalco Limited at their private siding of Messrs. HIW. OP number 2 never asked about the status of the private siding agreement as quoted by the petitioner. Let me read it again. In response to the amendments made in 4M, it is to state that the contention of the petitioner at para 4M is not correct. OP number 2 by letter dated 2/3/22 requested the OP number 3, that is me, to communicate the status of Hindalco Industries Limited at the private siding of Hirakud after 31/5/2022. OP number 2 has never asked about the status of the private agreement as quoted. Look at the next paragraph. This lease agreement dated so and so was executed between Hirakud. Yes, it's a bi-party agreement, and East Coast is not a party to the said agreement. East Coast is duty bound by the conditions of the private siding agreement dated 28/9/2005, executed between Hirakud and East Coast. That is all I wanted to show your lordship, so that when your lordship read the impugned judgment, your lordship will only remember how these matters have been dealt with. So this was the position. I'm so sorry, my lord. One more paragraph, your lordship. My para 9 is what my learned friend wants me to show your lordships. In response to. My lord, over the page, kindly see, my lord, over the page 10, second part of it. The East Coast Railway is bound to only the conditions of the private siding agreement dated 28/9/2005, executed between HIW and East Coast Railways. Order dated so and so reads as followed. Your lordship may not, I'll not trouble your lordships with all that. Your lordships have seen the status quo order, etc. Lord, can I kindly see, Lord, one more paragraph, para 11. Page 11 at the bottom. Page 11, para 11?
No, page 16.
Yeah, I'm sorry. Page 16. Yes. Kindly see, my lord, page 14. Last paragraph.
Any change in the
condition of the private side agreement is subject to the amendment of the agreement. So that is clause 33, if your lordship remember, lords. The 2005 agreement said if parties want to amend this, then that has to be done by following the proper process followed under clause 33. For such an amendment in the agreement, it is quite essential to identify the authorized signatory of the company. Kindly note, is very important, because at that time it was Regus. For most of the time, pursuant to the NCLT order, Regus was writing. Later on, Regus goes out. In the instant case, OP number 1 by letter dated so and so requested the petitioner to furnish a copy of the Board of Directors resolution appointing the resolution. However, the petitioner failed to communicate, etc. etc. That's all. No, that's all. Now, my lord, now I will go to. I had given your lordships a note, a spiral note on the first day. Kindly see, my lords. What is spiral bending there? If your lordship sees page 21, the page is at the bottom, my lords. Something called a note 2. My lords have it. This is what your lordship had asked me on the very first day. Now kindly see, my lords. The second question that arises for consideration, my lordship, grateful, is whether the present appellant Hindalco can maintain its claim or enforce any rights under the 2005 agreement, where formal parties to the agreement are HIW and Railways, particularly in view of the doctrine of privity of contract. At the outset, it is submitted present case, the present appellant Hindalco is not really hit by the doctrine of privity, in as much as the 2005 agreement expressly recognizes Hindalco as a co-user and assigns obligations upon it. In this regard, reliance may be placed on column 15, clause 15b at page 102, wherein the said clause expressly stipulates that Hindalco as a co-user would be responsible for payment of all railway dues arising out of the grant of such facility. Your lordship may only remember, we were discussing that day that tollage agreement has to be separately executed. Now, there is no tollage agreement so far as this case is concerned. Even after 2005, there is no tollage agreement because that says it may have a tollage agreement. Here there is no, on facts there was never any tollage agreement from 2005 onwards till now. In view of the above, Hindalco is not a stranger.
You are referring to a clause where they would
assign
that money and pay it to the applicant, and applicant will pay
applicant may have a contract for tollage. This agreement, notwithstanding running from 2005,
Collected proportionate.
yes. So that agreement was never there. So maybe, my lords, parties thought there was no need for tollage. And co-user, your lordship, the other day asked me to define somewhere. It is there in the judgment. I'll show to your lordship when it comes there. It's not a party of the agreement, but it's there. But then, moreover, in the fact and in view of the above, Hindalco is not a stranger to the contractual agreement, but rather a recognized co-user, an entity specifically contemplated under the agreement, party to whom the contractual obligations were conferred. Moreover, in fact of the conduct of the parties over several years, further reinforces the aforesaid position. For a context, it is stated, upon failure of the respondent one to discharge its dues of the private side agreement, Hindalco has continuously discharged its obligations. So I have discharged all the obligations. The material and record would demonstrate that Hindalco has made payments on behalf of HIW from 1990 till 2024-25, paid license fees for 25-26. And even today I'm paying
for establishing privity.
Privity. Your lordship may see, B4.
B4 are the rulings.
Yes.
Which three rulings you have.
No, I am saying beneficiary. On the beneficiary. Beneficiary. So undertaken substantial railway related expenditure remained the sole and Roman for is little important. Remained the sole and exclusive operational user of the siding since closure. Although I was a co-user from 2007 onwards, I am the sole user. Railways have consistently accepted such payments from the Hindalco and acted in terms of the status as a cooperative so and so. It is settled law that where a third party constitutes an intended beneficiary under a contract, such case falls within the recognized exceptions of the doctrine of privity. Lord, I have referred to some judgments. Lord, I will not read them. Only the footnotes I will read, Lord, to save time. Lord, here in that clause is a very interesting case. One pilot, Lord, there was a Lufthansa agreement with the Oberoi Hotel.
Yes.
And that pilot had no privity of contract. It fell down and he suffered injury. He was treated here. He was taken to Germany. They said, no, you have no privity. You are not a party to this contract. He said, no, I was a beneficiary because for me only this agreement was entered into. But you see, there's another judgment, Mother Trading. But may read this. The Union of India entered into a contract with the foreign supplier for purchase of goods, which specifically included provisions for 5% commission to be paid on the Indian agent. The government of later unilaterally amended the contract to re-recognize the plaintiff and substituted a different agent, thereby denying the plaintiff the earmark commission. The court held that the plaintiff was not a signatory to the contract, created an equitable exception to the privity because it specifically earmarked a benefit the commission for the plaintiff. They said you will get some commission even though you are not a signatory. It was observed that where a contract is intended to secure a benefit for a third party or creates a trust, in the same principle is reiterated in Narayan Devi, all these judgments are there. All this homework was done, my lords. Your lordships had told me and I put all these boys, I said, I'm an old man, you better start working on this. In view of the above, it is respectfully submitted. I'm sorry. The Hindalco's claim is clearly maintainable because Hindalco is expressly recognized under the 2005 agreement itself. Contractual obligations are cast upon Hindalco. Hindalco has continuously performed the obligations under the agreement over decades. The railways themselves have consistently treated Hindalco as a cooperative co-user. Hindalco squarely falls within the intended beneficiary exception to the doctrine of privity. What are you saying? Which one? Yes. My lord, there is one more order I want to show you, lordships, of your lordships court, my lords, as to who owns this infrastructure, this railway infrastructure, my lords. There was a matter before your lordship. You have copied me, please. Your lordships will see, my lords. There was an accident in this very place, in this very railway siding. And the question was, who will pay compensation? Mr. General Learned Advocate had moved the writ petition before the bench on 10th May 2022. He had submitted his clients or relatives were deceased. Death occurred when the check at so and so.
So Railways is held to be the owner, legal owner of this one, therefore liability to pay the compensation.
I'm great. Para 4, if your lordship sees minutes.
That was under the Railways Act.
Yes.
For
What they say
the welfare legislation. Therefore,
they not kindly see 4, because my status has also been discussed here. OP number 4, that is me, is a co-user of the railway siding with the applicant under the agreement. Under the perusal agreement, it is clear that the siding, the same agreement, 2005 agreement. On a perusal of the agreement, it is clear that the siding continues to be railway property, though located in the premises of the applicant. That's the 9 minutes. Same agreement. They were also interpreting 2005 agreement. But I'm trying to be as quick as I can.
No, we don't believe that you are old.
That is what we were discussing before your lordship came. I said, young man, sit down. He said, old man is walking. So it was, you know, there are certain other clauses of the agreement. I'll not trouble your lordship with now. Go to now. Take out my copy.
Yes.
Well, would your lordships kindly now be pleased to see the impugned order before your lordships? Yes. That order your lordships will get, my lords. It is Annexure 1, page 42.
Yeah.
Kindly see the first paragraph. The writ petition is preferred by the petitioner challenging the legality and propriety of the actions of the opposite party number 1 and 2, providing indent, kindly note minutes, providing indent to the OP number 3, despite the termination of the agreement between the petitioner 1 and the OP number 3 by efflux of time in an illegal, arbitrary manner, thereby jeopardizing the interest of the petitioners. No, this is exactly the question, that the relief that has been granted. Two things. One, the petitioner ran a case that I had an agreement in 2002. That agreement has come to an end in 2022. 20 years has lapsed. And therefore, my lords, that agreement having been terminated, the railways is illegally and arbitrarily.
Where is termination?
The 2002 agreement. That first agreement.
Termination of the agreement by efflux of years.
That was for 20 years, it got over.
Over. There is a case of termination. It's a case of determination of contract by efflux of time.
Your lordship is right.
So termination is another concept.
Yes, termination is while it is pending, you terminate it. So therefore, my lords, 2005 was completely out of real consideration, if I may say so, with great respect, Lord. And by which time the railways had already filed a counter saying that, look, we have nothing to do with the 2002 agreement. In their counter specifically stated, and our case is that under 2005 agreement is entitled to continue. Let me read further minutes. Kindly see minutes, paragraph D. My lords have para D minutes over the page.
While
this agreement was subsisting, the petitioner, I'm sorry.
Yes. Paragraph
D at page 44. While this agreement was subsisting, namely 2002 agreement was subsisting, the petitioner entered into a private siding agreement with East Coast Railways with an agreement dated 28/9/2005. This agreement dated 2005 incorporated the petitioner's subsisting agreement with Hindalco and granted Hindalco permission to co-use the railways. This is factually incorrect. Contrary to the counter, nowhere in the 2005 agreement will your lordship see any reference to the 2002 agreement. The argument, the submission was, and the Honorable Judge is recording, that because you had a 2002 agreement, you became a co-user, and therefore the 2005 agreement was executed because of this. With great respect, my lord, this was not the case of the railways, and this is also not borne out from any record. Now your lordship may kindly see paragraph G. Lord, if I am little quick, your lordship may tell me, I'll go slow.
No problem.
Your lordship may see, kindly see, my lords, F. Your lordships have F, my lords?
Yeah.
After a series of orders and proceedings before this court, my lord, these are not contentions, these are findings of court. May I clarify that, my lords? Your lordship may see the facts giving rise, if your lordship don't mind, my lords, paragraph 3, the facts giving rise to the present petition can be summarized as follows. So these are what the court's findings. These are not the submissions, because the submissions will come later. My lord, if your lordship sees F, after a series of orders and proceedings before this court and the NCLT, the matters finally came to a quietus by the judgment dated 18/11/19 of the Apex Court in civil appeal number so and so, wherein the Apex Court had directed that this court ought not to proceed in the matter when LCLT was in session of the matter and moratorium, all this had gone by that time. By that time, all that is said in para 5F was no more available. NCLAT over, Supreme Court also over. Let me read further. In terms of the orders of the Apex Court, the learned NCLT Cuttack Vide's order dated 22/12/21 was pleased to dispose of the application under Section 7, filed by Nandakani, approving the resolution plan of one Regus Impex. As such, with the orders dated 22/12/21 of the NCLT Cuttack, Regus took over the affairs of the petitioner company. These are all errors of record. By the time the judgment was delivered, all this was over, long over. The said Regus having now stepped in, these are the errors which have crept into this judgment, and therefore the result. My lord, these facts would have been correct if on the day these were all prior to the NCLAT, prior to the Supreme Court and everything.
The change of substratum is not taken note of. That is the
It's quite apparent, telltale. The said Regus having now stepped into the management of the petitioner company, attempts were made to sort out all its affairs, noticing discrepancies in payments by letter dated 14/1/22 sent to Hindalco. Who is writing? Let us see who is writing. My lord, Regus, who is Regus? The said Regus having now stepped into the management of the petitioner company, attempts were made to sort out all its affairs, and noticing discrepancies in payment, letter dated so-and-so was sent to Hindalco, seeking outstanding dues to the tune of so-and-so, rental to the tune of so-and-so, towards supply of materials, and stating inter alia that in case Hindalco wanted to continue with the agreement, it ought to pay the outstanding dues. Let us stop here for a minute. Regus, I could not have paid. But if HIW wanted me to pay, I am willing to pay now. Let them say what is the amount they want. Let us read further. Having not received any notice, intimating interest, extending the lease agreement, the petitioner with a letter dated 17/5/22 once again sought payment from Hindalco of the outstanding dues and stated that in pursuance of the terms of the agreement dated so-and-so was expiring on 22. And who was saying that there is a clause under the 2002 agreement that you apply before 3 months? Whom will I apply? And who is writing to me? HIW is not writing to me that if you wish to extend, please come. Because by that time, no one knows who is the person with whom I will communicate. And IBC moratorium was on at the relevant time. Railways are filing an affidavit before your lordship that we wrote 6 letters. Nobody received. So whom am I supposed to speak to? Let me read further, my lords. it is pertinent to mention Hindalco has also sought to be a resolution applicant in the CRP proceedings before NCLT, but failed in its attempt. Hindalco has challenged the order of NCLT Cuttack before NCLAT, New Delhi, wherein NCLAT with its letter dated so-and-so, although has not stayed the order of dated so-and-so of the NCLT, has directed no further disbursement to be made in pursuance of the impugned order, approving a resolution plan and further directing status quo to be maintained. Well, by the date of this judgment, all this is gone. All this is gone, Millets. With this background, it is alleged that instead of approaching the railways, now kindly see, that is the background and therefore the cause of action. With this background, it is alleged, instead of approaching the petitioner with whom East Coast Railways has entered into a private siding agreement dated so and so, East Coast Railways by letter dated 2/3/22 sought for the information from Hindalco as to what is the status of the petitioner's company and Hindalco's relationship was post 31/5/22. 31/5/22 is the 20 years expiry date. Given that the agreement between the petitioner and company was to expire on 31/5/22. Let me pause here for a moment. Railway says, I'm writing 6 letters. No one is replying. Rigas says that this agreement is coming to a new, not who is Rigas, not that person who started the collusive petition. That gentleman is saying that you now pay me, but assume I would have paid him. What would I have paid today? Let me read further, because the language of J is with this background. So the whole background on which we are proceeding now, in my humble submission, Lords, is non-existent in law. The person who was creating the background had no locus even to do that. And in any case, Lord, he is a fraudster.
Because of the finding.
Finding and nothing, no interference by the Honorable Supreme Court. And let me see K. Yes, and kindly see, Lord, but my learned friend says is, after J, kindly see now K. Hindalco, by its letter dated so-and-so, has replied to the East Coast Railway dated so-and-so, stating that the learned NCLAT Delhi has directed maintenance of status quo as regard disbursement disbursement pursuant to resolution plan approved by NCLT, Cuttack as well as with respect to the assets of the company. It then went on to request East Coast Railways to permit it to use railway siding after 35/5/2022 until the final disposal of the proceedings of NCLAT. This is what I wrote to them. I said there is a status quo. Allow me to work. The petitioner companies agreed that despite the expiry of the agreement dated 28/6/2022 on 28/6/2002 on 31/5/2022, East Coast Railways permitting Hindalco to use the private rail tracks and locomotives in absolute illegal, arbitrary manner, prejudicing the interest of the petitioner. Lord, let me stop here for a minute. There is a 2005 agreement which is noted in the preceding paragraphs, at para D. Now, the finding is that, look, that 2002 has expired. Now your continuance is illegal, arbitrary and prejudice. That means 2005 never existed. The petitioner submitted that despite making several representations before the East Coast Railways, ECR has continued to permit Hindalco to use the railway tracks and locomotives belonging to the petitioner against the arbitrary and illegal actions of the incident petition has been preferred. And one thing very interesting is, I am using this to the prejudicing the interest of the petitioner. You saw the line minutes. In the fourth line of para 4, illegal, arbitrary manner.
Prejudicing the
what is the prejudice called? I ask myself. You want money from me, you take it. You can't use the line. I am using the line. How is your interest being prejudiced? It's a public infrastructure given to you for using your own. Admittedly, you don't have any use. I am repeating it time and again, I know, Millets, but that's the crux of the matter.
Public property.
Public property, you don't have a requirement. How it will be prejudicing your interest? It can only prejudice his interest if he tomorrow says that I need it for myself and my requirement is so large that I can't accommodate you.
Or you are not paying.
Or you are not paying. My lord, all these facts about NCLT, NCLAT, etc., my lords, was there before the learned single judge. And by the time of the judgment, everything was over. Matter was heard on February 25th. The judgment was delivered on 9th of May. By that time, entire NCLAT.
The date of NCLAT order is?
Date of NCLAT order, my lords.
This is post reservation.
No. 9th January 23. Yes, 1 second. 9th January 23 is the NCLAT order. This Supreme Court order. Writ petition was filed thereafter. The amended writ petition was filed in 24. The judgment came much later.
Everything was already there.
Already over. But that is why I said there was no. Just relax. Don't do this. Now the submission, my lord, is that by the time the judgment was delivered, even Supreme Court was over. No.
August 15. Supreme Court order is August 2020.
Yes. Lord, when did you?
The date when they applied for restoration, do you have that date?
Let me straight away answer this question. We just pulled it out, Millets. This was filed on 20th of November 2025.
2011-2025.
And your lordship may come down a little down, Millets. Status: defect matters not refiled after 90 days. So therefore, my lord, the time also gone.
Under the Apex Court procedure rules.
Yes.
Which you may be aware because you appear there. What is the legal position after the expiry of 90 days?
When it comes before the Registrar General Village, which is what the order at 380 we showed village. After defects were not cleared after 90 days, they keep it pending. They give us opportunity of hearing if you want to clear defects. Then that detailed order was passed. It's disposed of.
That order is passed
by honorable judgment. If I am not wrong, let us see that.
Yes.
Justice Bindal.
Yes, sir.
Why we saw that?
Yes.
By the court itself.
Yes.
And this is after that.
And this is after and filed after how many days?
This was 2023. They were dismissed.
Dismissed in 2023.
No, they filed on November 2025.
This is a
and the restoration was filed, my lords, on 2011-25.
Yes, that's what.
Almost 2 years after this. And the status as of today, defective matters not refiled after 90 days.
No, that refers to main matter. No,
this refiling. This one.
No, even this is defective.
Even this is defective. I was at page 47, para 4 minutes. The petitioner company is aggrieved that despite the expiry of the lease agreement dated so and so, on so and so, the East Coast Railway is permitting Hon'Ble to use their private rail tracks and locomotives in an absolute illegal and arbitrary manner, prejudicing the interests of the petitioner. The petitioner submits that despite making multiple representations on so and so before East Coast, I think I have read this paragraph. Again, kindly turn over the page. Then submissions of my learned friend are noted at page 48. Lordships have it.
Yes, arbitration proceeding.
Yes, page 48, the learned senior counsel, Mr. Thakkar, for the petitioner submits that the objection taken on behalf of the relief of the petitioner lies in arbitration proceeding because the railway took a position that there's an arbitration clause, it should go there. and not by way of a writ petition as devoid of substance on account of various decisions of the Supreme Court holding an alternate remedy did not place any fetters on the powers of the High Court under Article 226. In support of the submission, Learned Counsel relies upon all these judgments notes. I will not trouble you with all that. Kindly see para 7. Moreover, it is submitted on merits that the acts of the respondent in permitting R3, that is me, to use the private siding of the petitioner by accepting indents placed by the R3 and supplying wagons pursuant to such illegal indent is illegal, unfair, arbitrary. This is more so as the respondent was fully aware that R3 is not entitled to use the railway lines and the private siding of the petitioner after expiry of the lease agreement dated 31/5/2022. Now, this would be right if there would have been no 2005. It is also alleged that there has been gross violations of the principles of natural justice, inasmuch as the petitioner was never questioned for the status of the agreement with the respondent number 3, and instead respondent 3 was approached by the respondent number 1. So what is being argued is that, look, you railways, you did not ask us, you asked Hindalco, because Hindalco was the co-user. I was the applicant. Instead of asking the applicant, why did you ask the co-user? There are two possible answers to this. One is they say in the counter, we write 6 letters, no one is there. Everything comes back unserved because there is nobody there in the registered office. And B, it is me who has been paying all the charges. It is me who is only using it. So therefore they ask me. Who else will they ask? There can't be a third person they will ask. And 2005 itself says, you the co-user shall pay. Now let me read further. Para 9 minutes. In any case, the appeal pending for NCLAT has been disposed of by judgment and order dated 9/1/23 in light of the same status quo, if any, has also come to an end. Therefore, the respondent number 3 could not have permitted the use the private siding in such an arbitrary manner.
Let us go to findings. These are the submissions.
Yes. So your lordship may only see one more submission, and then we will come there, lords. Paragraph 10 is what the learned DGSGI had argued about arbitration. So, right, lords? And then kindly see 11 was my submissions. And what did I say, lords? I said that the OP number 3 to use the private siding is in line with clause 19C of the private siding agreement entered into. That was the defense we had taken at that time. It is further submitted, private siding has not been terminated. This is very important. By the East Coast Railways, that is also the counter of East Coast Railways, not terminated, and therefore is using. Agreement is still in force under the agreement, so and so. Therefore, as railway administration exercises complete control over the operations, the permission to the sea can be granted without any reference to the petitioner hearing. Now, my lord, the learned single judge phrases, Lord, 3 issues are framed. One is whether the court can exercise its jurisdiction in realm of contracts. Those line of judgments, the ABL and all that, my lords. If there is arbitrariness, Article 14 violent, etc., it is mentioned. And then alternative remedies is because of the arbitration clause, and then whether court ought to interfere. I'll straight away come to the last one, so that I don't waste your lordship's time. The last one, my lords, begins at yes, para 38. Whether this court ought to interfere in the facts of the present case. When the present petition was moved in 2022, the respondent number 1, your lordship may only note, my lord, it was filed by Regus. Regus and Hindalco, Regus and HIW filed jointly. The respondent number 1 challenged the maintainability of its preliminary objection on the grounds of existence of arbitration proceedings. Pending proceedings to NCLAT, status quo passed by NCLAT. As discussed above, it is no longer a recent era. Mere presence of an arbitration agreement by itself will not be house. This is actually a repetition of what he had held in the earlier paragraphs. This court now considers, this is important, this court now considers it apposite to rely on the relevant clauses of the agreements entered into between the parties The same are reproduced herein for the sake of convenience. So first is the 2002 agreement. Your Lordships have seen that. My Lord, now we will come to
2005 agreement.
and then we come to 2005 agreement. This is the private siding agreement. Your Lordships have seen clause 15. And 15 and 19, both your Lordships have seen, minutes. Kindly see para 40. This court now draws its attention to the respondent number one's own letter of 2nd March 2022 and reproduces a part thereof. This is annexure 17, but I'll not trouble your Lordships with that one. Let us read what has been quoted. In terms of clause 15C of the private siding agreement under reference that was executed in ECOR and HIW, booking and delivery of Hindalco erstwhile Hindal railway traffic is continuing at the private siding of HIW. However, while it is referring to the lease agreement, under reference it is understood that the period of lease agreement between HLW and Hindalco for railway tracks associated is going to expire and so. In view of the above, Hindalco status at the private siding after 31/5/2022 may please be communicated to this office at the earliest. They're writing to me. And what do they reply, my lords? Upon receiving the reply with the request to maintain status quo from respondent number 3, once again, wrote a letter. Your appeal by letter under reference of HIW siding has been examined. Railway Board circular dated so and so stipulate that private siding is agreement only for end users. However, siding may permit multiple co-users as per the definition of co-user given in para 2F, 2V of the private siding policy and inform the zonal railway at least 7 working days in advance. Zonal railway will take necessary action for inclusion of such co-users within 7 days. On the issues mentioned in a letter under reference, authorities directed that decision of INCLAT may be communicated. And this is why, because we always kept railways informed about all the proceedings that are happening. Now kindly see 42. Here this court deems it appropriate to look into the definition of end user and co-user, the question which had fallen from your Lordships. End user is defined in clause 2.6, means user who owns plant, manufacturing unit or production unit, mines and the siding is for the purpose of his exclusive use or for handling of products being used and manufactured or produced therein, and this also includes sidings of so and so. Co-user. Now co-user. Co-user is defined in clause 2V as refers to permission given to a railway user other than the owner of the private siding by the railway administration. Not made it again. Refers to permission given to a rail user, that is me. Other than the owner, applicant, because applicant, if he uses, he's the end user. He's not a co-user. So co-user has to be somebody other than the owner. And who will give the permission? By the railway administration for using the siding for handling of his own goods, traffic at the siding, subject to the provisions of the siding. So therefore, my lords, if somebody wants to be a co-user, the permission to grant will be moved by the applicant, but ultimately approved by the railways. In the present case, there is no disputed question of fact as the respondent does dispute and cannot permit the See. Your Lordship may only note while I am reading para 43, this position is just contrary to what has been said by the railways in their counter affidavit at para 7, page 11, which your Lordship saw this one.
We saw that.
Yes. Your Lordship may just note that. Yes. In the present case, there exists no disputed question of fact, as respondent 1 doesn't dispute and cannot permit the RT to use the railway lines of the private side of the petitioner after expiry of the lease agreement without consulting the petitioner in absence of any application made by R3 to the railway administration to use the primary. Where does this finding fall from? What has 2002 got to do with 2005? So therefore, my lord, does 2005 say, let me ask myself, let us test this. Does 2005 say, you Hindalco have been permitted because you have a 2002 and this co-user status will come to end in 2022, doesn't say so. On the contrary, what it says is that you are a co-user and the agreement says under clause 33, if it has to be amended, it has to be amended as per 33. The submission is this. My lord, HIW could have written to Railways, I want to amend this agreement. I will exercise my option under 33 and now I will say that my permission is withdrawn. You please amend it under 33. And it was for Railways and HIW to sit and decide mutually whether such an in fact, Aarti had also expressly stated in its own letter of 24/5 and 35 that it would approach the person who came in control of the petitioner company post disposal of the enclave in order to obtain permission to use the railway siding post 31/5/22. Let us accept whether it is correct. What I had said, let the enclave proceedings be over. Whoever is in charge, I will pay him. That is my position even now.
You are ready and willing
Of
to
course,
pay.
lords. Of course. Lord, why will I not pay? And this order is before enclave.
This order was not.
No, obviously.
Order was not.
Not by letters saying that now the matter is pending before enclave. There is a moratorium. I am paying you, I am not paying him. Once the enclave decides, then I am willing to pay. Whoever is in control, not? Whoever is in control. May not take an example, not? Tomorrow enclave is set, would have been set aside in the Supreme Court. Let us assume this. Then I would have paid records.
Only to whom amount becomes payable, going by your version, changes.
That's all. And, my lords, this final decision came pursuant to the enclave judgment. And if your lordships accept that no enclave judgment is still not finalized, notwithstanding dismissal, notwithstanding restoration, it has not attained a finality, then even today we don't know who is to be paid. Or at the highest, my lord, your lordship will say, go to the IRP, pay to the IRP. That IRP is also under investigation. Right? My lord, may I read further? It appears from the documents placed on record that the only explanation given by the R1 for not acting pursuant to the repeated request of the petitioner is the letters addressed to the petition in the past at a registered office returned undelivered, and therefore it did not attempt to make any further communication. This reasoning, in the court's opinion, reeks on non-application of mind, nullified, illegality and arbitrariness. All these three, well, I would say the shoe is on the other leg. You know, Justice Chinnappa Reddy had given an opinion. He said, I said whether there will be contempt or not. He said the boot is on the other leg. Kindly see, my lord, can the actions be nullified? So, nullified, illegality, arbitrariness, all these are necessary to exercise your lordship's jurisdiction under Article 226. My lord, kindly see further. And not a lie. I'm sorry.
Therefore, we said, when you said that you are old, we did not believe.
My lord, why I was rushing for two reasons. One is your lordships have two matters after 2 o'clock. I have one.
Yes.
I was wanting to finish it so that my learned friend could.
No, we have to take the subject. Yes, due regard.
No. I will
not. Have paucity of 10, can we say?
No. I'm grateful. No, my lord, I'm grateful.
The litigant should feel that
yes,
has been duly heard in the matter.
My lord, tomorrow your lordship may fix it at 12 o'clock. Because those two matters are not going to finish today.
That is humbly submitted. It permits with my learned friend also. Since he has, I understand, more or less concluded, but he has some submissions more to make. I was humbly submitting. If it commences to your lordship, a slightly different approach, which will not prejudice him. If I could be permitted to conclude my arguments, he will have the he will have the last.
I will just finish.
In reply, he will finish.
I will just finish. Whatever.
I will finish, and in reply, he can conclude everything. I will not come back to trouble your lordships and reply to reply.
No,
and we'll file a note, my lords.
We can't halt the flow at all. we can't hurt that. That will be very unjust to the litigant. Now, he is putting forth a particular version. He should be allowed to complete it fully. It should fructify to his satisfaction, reasonably.
Perhaps.
Therefore, that may not be. No, that may not be correct.
Lord, can it be 12 o'clock tomorrow?
Interjecting.
Can it be 12 o'clock tomorrow? Or 12
in all fairness, he is saying that, but that is not the way. Very frankly, because we also have to complete that way.
2 o'clock, your lordships have two matters to do. One is my matter, and the other one is the Advocate General is addressing the lordship.
We take a chance at 3:30 in case of.
No, we do not. We can't kindly do not pressurize.
Right.
We are not in hurry. We are not in hurry in deciding the matter. We are past things all right, but no hurry as such with us. There is no reason to be hurrying.
12 o'clock tomorrow.
Because consequences will follow. It may affect you. It may affect him.
Yes,
do not.
I bow down.
That will affect the very industry itself.
Please, sir. Maybe come back at 12 noon.
Let us.
Grateful.
The problem is this, my instructing counsels are telling me that this matter has to be heard and you can't do it at this speed. And your lordships have spent so much of time on this, and I thought my learned friend was coming all the way. And he is there from the beginning. He's always telling me from behind, show this document, show that document.
So God gives disciples to punish the guru. Some other wish. Because we are not possible for us. We are in the midst of the employees matter. And it is already another matter. Yourself, yes. Mr. Paddy said it's a very important matter. Yes. Has to be taken. We agreed to take that. Now you are saying, expressing some difficulty. No issue. We are not eager to hear any matter as such.
Not
but we learned a lot from your submission. This much
it's such a pleasure to argue.
Well, that's may I just, instructing counsel will always have his submissions. Learned senior counsel is there. He's addressed. Your lordships have been very patient. Your lordships have heard us for 5 days now. This is the 5th day. My difficulty is only this, well, I'm suffering an interim order since January, which is unconditional. My learned friends' clients are using my property, 253 acres and 12 kilometers of railway lines without paying a fine. I have not got into all this matter because this is not the forum for determination of our money claims.
Have you ever seen Ashok saying like this?
I have not. So, that is why I'm a bit surprised
that, will not say that
the instructing attorney will learned senior counsel will.
We should tell the truth. We have great respect and admiration for this tall person. Really, we don't
even
I have respect for everybody.
Yes.
But our respect for Mr. Ashok Parija is something enormous. We are constrained. We are compelled to say this from within, from heart. We are telling because I have been seeing Parija for the last 1 year.
Lordships are being very kind to me.
No, not like that. I am telling the truth as a judge. That's all. We have no other than to tell the truth. So we are not eager to decide any particular matter.
No, your lordships are not. But it's only because we were insisting.
Let it go before some other things because it's a heavy matter.
I'm extremely sorry, Manoj.
No, why you should be sorry? We should be sorry actually. So
if Mr. Parija is in some difficulty today, he can conclude tomorrow. But it's not because this finally see our predicament also.
Before other bench we are saying, push this matter before other bench on Monday, Tuesday. Wait, Tuesday happened?
Yes, ma'am.
Tuesday.
The interim order to continue.
Interim order to continue.
Lord, can be 1 week after.
No, very well, no issue. Within 1 week, nothing.
Yeah, 1 week after.
Yes.
There's some medical issue at the family.
Very well, no issue. You take whatever time.
Lord, we commencing 13th.
13th.
13 July, yes.
Grateful.
But we should tell you, I learned so much from you.
No.
Yes, so much law.
I'm humbled.
Really. Yeah.
Item 24, data paying monthly pipeline of total percent.
Yeah. Rouse Roy and others can go for a round, and you learned AG also go for a round with them, but not away from our court.
No.
Be approachable to us.
Should it be at 3?
Sometime.
Should it be at 3 so that I can? I'll come at 3.
3, you are free. You can. You will not be that free. I know. We know, but
No, I'll come back. But I'm already here since I am
No
prepared.
issue. Come by. Yes.
I prepared a note.
That's very good. Nice out. In 1986, the apex court said that the Inapparenti said in that LIC of India versus Escort.
Shareholders.
Right. 86. That means about 40 years ago.
It's a 5-judge.
That time has come for prescribing time slot for lawyers to argue the matter. And for judges also. We cannot go on wasting time of the party. Yes.
Before your lordships takes up the facts, please. And Millets, may I just, what is the issue about? Millets may not see any papers.
No, we have read the papers already.
Yes. So Millets, here, the case is that I am a person from Raipur, Chhattisgarh. There was a high-level delegation that went from the government of Odisha to invite prospective investors from Raipur that please come and invest in our state and set up industries. Pursuant to that, we were one of them who came and we wanted to set up a plant.
So you came on invitation?
Yes, it was not, it was a conclave kind of a thing where people from Odisha, they visited and they said, ki whoever are industrialists, you can come and invest in our state. So that was what, and on the basis of that, we came and we were said that there is a state level single window clearance authority, a high power authority, where it's a single window, as the name suggests, Millets, everything happens very smoothly there. So Millets, we came. What we did, Millets, we wanted to set up a 1.2 MTPA iron ore beneficiation plant and 0.8 MTPA pellet plant at village Hon'Ble in Tehsil Koida at district Sundargarh. Well, as this name assumes a lot of importance. Village Hon'Ble. The state level single window clearance authority approval was given to me. After being given,
called a state level single window agency.
Clearance authority, SLS WCA.
The clearance was given on which day?
On Millets?
You applied on which date when they gave it?
Yes, we applied on 2/6/2023. After doing all the due diligence. 2/6/2023.
This is your proposal and
Yes, my application to EPCOL. EPCOL being the nodal agency, we have to apply through EPCOL.
And clearance was given on
31/10/2023.
What the clearance says?
The clearance says that you can set up a plant. I'll just read that, Millets. 139. Now, before I go there, I wanted to show to your lordship what is the statutory framework, how this SLSWCA and EPCOL functions. So Millets will just permit me to place para 22 and 23 of my note. Page 5.
Your note?
Yes. Yes.
Yeah, you can give a thumbnail.
This is just
description of statutory framework.
Yes. Because there is an...
Is there any legislation?
Yes.
What is that?
That is Orissa Industries Facilitation Act 2004.
State act?
Yes, it's a state act.
Okay.
Now, Millets,
industry is in a concurrent list or state list?
it is in the state list. Because yes.
Industry, but how Industrial Dispute Act has been...
No, Millets, that would be with relation to labor and employment, Millets. So probably that's why, Millets. Okay. Maybe, or Millets, this particular thing for facilitation would, so Millets, I'll just check, Millets, it would be in concurrent list probably, Millets.
Yes, that's it.
It appears that. Now, Millets, may I show?
Can any youngster look into? Matter relating to industry is in concurrent list or state list?
We are seeing that.
Okay.
Now, Millets, I'm placing section 4 of
324 list.
324 of concurrent list.
Yes.
Brother said.
Yeah.
Any central legislation occupying the field?
Not to my knowledge, Millets, under this, because this is what is being referred to, Millets.
Whether your state act received the assent of the president?
Yes, this is.
Then there is a central act.
No, it is not with assent of the president,
But governor.
It's the assent of the governor on 24th December 2004.
Yes.
Now, Millets, I rely upon section 4 of that act, Millets, Orissa Industries Facilitation Act.
What the act says?
I'll just hand over a copy of that.
Thumbnail description. Yes. Then we can go through the provision. What is the object of the act?
Hand over a copy of that note, of that act, Millets, I'm sorry.
Well. Thank you.
Let's have that. Let's will kindly take section 4.
Let us see the preamble.
Yes. An act to provide for the constitution of clearance authorities at the district and state level for scrutiny, consideration, and final disposal of the applications of the entrepreneurs proposing to start industries in the state and for matter connected thereto, therewith or instituted there.
Right.
Now, Millets will kindly take first, Millets, the definition of state level single window clearance authority, which is section 2M. SLSWCA, that is, Millets, if I may refer it to as SLSWCA, means a committee constituted under section 4 of this act. Now, Millets will kindly take section 4. Government may, by notification in the official gazette, constitute from time to time a committee under the chairmanship of the chief secretary, known as the state level single window clearance authority, hereinafter in this section referred to as the said authority, consisting of such other ex officio members as may be specified there. Millets will kindly take subsection 5.
You also just read.
Yes, Millets, I'll read then the entire thing. The said authority shall examine and consider proposals for industrial and other projects to be set up in the state where the amount of investment is rupees 3 crores or more, but less than rupees 50 crores or such amount as may be fixed by government from time to time. Every member of the said authority.
What is your investment?
Let's say it's around 130 crores.
But less than 50 crores, it's it?
Yes, it has been revised from time to time. That
you have to say, that's very important. Your right arising under the act
because
is one thing. Your right arising towards the act is another.
Yes, but what it defines, Billets, is that it will be an authority for consideration of these proposals to set up industries. And
provided the investment estimation is?
It was in 2004, this was the amount, the pecuniary limits, Billets. However, that is undisputed because today SLSWCA has taken into consideration my proposal and given its approval.
All right, but when it comes to question of law, court will not be governed much influenced by practice and dispute. Law is undisputed.
Yes, that's good. Millets, there must be revisions in the meanwhile, Millets. I'll ascertain
that. Okay.
Now, Millets, subsection 5. May I read subsection 5, Millets?
No, 4.
4. The said authority may exercise the following powers and shall perform the following functions, namely, to meet at such times and places as the chairman of the said authority may decide.
5.
I'm sorry, Millets?
Go to 5.
5.
We have read it. Yes.
The said authority shall be the final authority in granting approvals on proposals for the projects under subsection 2 placed before it, and the approvals given by it shall be binding on the departments or authorities concerned, and such departments or authorities shall issue the required clearance within the specified time limit subject to compliances of the provisions of the applicable act or rules or orders or instructions by the industrial unit. So, Millets, there is a binding force of the approval, Millets, that is given by the state level single window clearance. Here, Millets, your lordship will kindly refer to Rule 2A of the Orissa Industries Facilitation Amendment Rules 2015, which has been referred to by the Honorable Single Judge.
Section 2A.
Rule 2A of the Orissa Industries Facilitation.
2M you started, na?
Yes, 2M is the definition.
Then section 4. More particularly
5.
5. 4, 5.
Okay.
Then
I have just
to turn to page.
Your lordship will kindly take this Orissa Industries Facilitation Amendment Rules 2015.
Good. Didn't you have a copy of it?
I have, yes. And also, Millets, in the meanwhile, I have pulled out the latest notification says up to 1,000 crore of investment. That is there since 2005. Now, Millets, Rule 2A, your lordship will kindly see, Millets. This has been relied upon by the Honorable Single Judge.
Okay. Preliminary project assessment application.
Yes. Every applicant who is not in possession of any land or not allotted with land for the purpose of establishment of an industry, or not in possession of land exceeding 25% of total land required for the project or for other activity, shall apply in Schedule 1 before filing of combined application form at Schedule 1A through the nodal agency. And I'll show Millets, this nodal agency is no one but EPCOL. Through the nodal agency, who shall, after examining the feasibility of the project, including, Millets will see, assessment of land, allotment thereof. So, Millets, there is an assessment of that land and also with relation to allotment of that land. And for other utilities, recommend the same to the concerned competent authority for approval of the said project.
So what comes up from that?
Well, here, this nodal agency shall forward forward to the competent authority after assessing the land and allotment thereof, he will forward to the competent authority. Now question arises, who is the competent? That is that SLSWCA, which is there in the Orissa Industries Facilitation Rules. That this is the amendment provision. The facilitation rules defines competent authority.
There are separate rules.
2004,
the 2005 rules.
Yes. 2005. I showed the amendment provision. 2A. Rule 2A.
Yes.
And now to show who is the competent authority to whom the nodal agency will report. Nodal agency being EPCOL, I'll show EPCOL is the nodal agency.
Yeah. Yes.
We'll see the definitions. 2G. Competent authority means the single window clearance authority at district, state, or high level clearance as the case may be. G. Let's see that.
Yes.
Now, your lordship, we'll see who comprises this state level single window clearance authority. Interestingly, it comprises of, I'm just reading out, Chief Secretary, Principal Secretary of various departments, Chairman cum Managing Director of IDCO, Chairman cum Managing Director of EPCOL, and such another, this is the constitution, this is the notification whereby SLSWCA constituents is defined.
Is 4.1 notification?
Yes, it's under 4.1. I'm so grateful. Dated 9th March 2005.
Notification dated
9th March 2005.
So
composition of SLSWC, the competent authority.
Yeah.
And Malos will kindly see that list.
Yes, understood. Yes.
Your lordship will see all high level people, they are sitting there.
It comprises of high functionaries.
Includes
all other departments.
Includes IDCO's chairman and EPCOL's chairman. Serial number 14 and 17.
Yes.
Ambulance will kindly take page 62 of my writ appeal to show who is the nodal agency here, because I have demonstrated who is the competent authority, that is SLSWCA. Now, who is the nodal agency, Bilals? Because it is this nodal agency who has to do that assessment of land, basis the documents that I have submitted. So, Bilals, your lordship will see the nodal agency, page 62 of the writ appeal. And I have, let's put this in my note at para 22 and
para 22.
22 and 23 of my note.
Your submission is there?
Yes, it's
let us see.
Of my note that I.
In what direction, with what ground you want to relate this?
I want to show Millards, a stand has been taken by EPCOL that look here, we are not identifying the plot of land that you will take. We are identifying only an area, say you can, okay, in village Bhanjapali, you can go and set up. But subsequently, we got to know that it has been reserved in the land bank for Runta. That is what IDCO says. So therefore, you take another alternative land. So that is their argument. Now, my humble submission before your lordship is that the very fact that they have given the clearance after doing the assessment and allotment as per the provisions of the governing 4.5, that itself shows that they very well know which patch of land I'm looking at.
So,
and it
approval is land specific.
Yes, that's what I wanted to. It is not like you go to village Banjapalli, just earmark which year and you take it. It's not like that. It has to be a well-defined area, and that is what the approval is given for. So let's kindly see who is the nodal agency at page 62. This is, Millards, I'm citing Industrial Policy Resolution 2022 of the Government of Orissa.
This resolution is drawn under which act?
Let's see. I'll just show. Since
Just to know.
Yes, I'll just look at it.
Because Apex Court said in State of Mysore versus Fernandez, 1960s Constitution bench judgment, where a policy is drawn in exercise of executive power of the state. Or a policy drawn in accordance with a statute or legislation, then the violation will not give you the cause of action. There the Apex Court was considering a Mysore PWD code.
It is not.
We want to know. I say that what is the status of this instrument?
Yes. I'll find that. I'll just read. This Millards, this policy resolution, Millards, is formed by taking into view what the Facilitation Act itself provides. So Millards, there is reference to, I'll just pull out Millards, Lordship, but there is no, I am not saying that there is any violation of the IPR. All I am showing, Millards, is under
policy is dated.
This is 2022, Millards. It's your Lordship will. Yes. Let's just.
Whether it refers to any provision of any statute? No.
It is relates to that Orissa Industries Facilitation Act. There is a reference to Orissa Industries Facilitation Act.
In the Act, is there any provision which gives the government shall draw the industrial policy for a block period of 5 years, 10 years, 15 years, 100 years?
Millards, I'll just
to know.
Yes, Millards, I'll just examine it. I'll just examine it.
Judgment, just make note of that. 69, I do not remember. 1960s judgment. State of Mysore versus Fernandez. CJ Fernandez versus State of Mysore. This is the AR 1967 SC 1753. Just have a note of that. My memory is playing trick with me nowadays. Correct page numbers, years, I'm missing them. Anyway.
Millards, we can draw as much of knowledge from your Lordships as much as we can in this limited time frame.
Yes.
Now, Millards, page 62 of the writ of appeal.
62. Policy framework. What you want to show by this?
3.1a. Who is EPICOL in this policy? Millards. EPICOL, or may I read Millards 3.1? The IPR 2022 shall pursue a multi-pronged approach for investment promotion by providing institutional and infrastructural support, pre and post-production clearances, competitive incentives, dedicated investment facilitation. The state government shall undertake focused initiatives to establish the state as an investment destination of choice. These will include A. Industrial Policy Promotion and Investment Corporation of Odisha Limited EPICOL as a nodal agency. For promotion of investment in the state shall be further strengthened to become a one-stop shop. That's the language for the investors.
Yes.
Having shown this, Millards, so Millards, if I may just summarize this aspect, nodal agency will receive the applications from proposed investors or industrialists. EPICOL will receive the applications. It will verify whatever is our requirement.
This industrial policy is for what block period?
This is applicable since 2022. The IPR.
In your case, all this happened after this policy is drawn.
Yes.
Before
2023. Now, this nodal agency identifies the land, does the assessment of that land, also looks at the allotment, and then forwards it to the state level single window clearance, who gives the approval. And that has happened in our case.
Section 4(5) is your case.
Yes. And that having been done by the state level single window clearance authority, it is binding on all departments, all authorities. That is what 4(5) says.
It uses the word binding.
Binding. The word binding is used. And Millards, there is also an overriding provision in Orissa Industries Facilitation Act. There's an overriding provision also, section 17. Now, Millards, that being the statutory framework, my case is that I have got the clearance from the clearance authority for that particular patch of land at village Bhanjapati. After having that approval, I cannot be said that you go forget about that patch of land, you go and identify an alternative patch of land. That is what IDCO says. That is what the case of IDCO is. Why? Because it is reserved in the name of Rungta. Why? Because Rungta wants to set up.
It was reserved when?
They say it was reserved
much prior.
Approval being granted to you. But that there is the dispute, Pillars. They say it was reserved for them much prior to when I entered into the picture. However, that is not the case. I will demonstrate that. I'll show the papers. I have applied for village Bhanjapali. They have their plant at village Kamanda. All the approvals that they have got till I enter into the picture are to set up their tailing pond of 125 acres at Kamanda. It is only after I apply on 2/6/23, 4 days later, an application comes that please give us land at Bhanjapali and Kusumdihi. I don't have to do anything with Kusumdihi. So that is my case. Just 4 days after that application comes, and Millards, one more interesting aspect.
4 days after clearance.
After 4 days after my application, when I
application before
was it
SW?
Yes, through the nodal agency, that is EPICO.
No, it was EPICO.
Through the nodal agency, that is
EPICO. That is what.
It is to apply.
Forwarded it to whom?
Millards?
EPICO forwarded it to the authority.
EPICO then
that is
Millards.
SLSWCA.
Yes,
and it sent it.
Millards, that we don't have that information, Millards, but approval has been given.
Approval is given after they also gave 4 days difference in applying.
Millards.
By application, is there anything which says first come, first grant?
No, I am not saying that.
Nothing like
no, I am not saying that's not
so
my
their
case.
application was also there when your application was there. Whether a doctrine of contemporaneous consideration will apply.
Millards, it can apply. Millards. However,
any ruling of any of our brother judges.
That's we'll look into that. However, Millards, my humble submission is that once you have gone through those files,
your clearance was granted on 31/10/2023.
Correct. After that, after the clearance is received, IDCO says, no, that particular land is not available. That is given to Rungta. You go and apply for.
When it says.
It responds. That is what I have challenged, Millards.
When it says.
Yes. On 29/12/2023.
That was the impugned order.
That then there has been further correspondence. Ultimately, 18/10/24 is what I have challenged, where they again say you go and apply for alternative patch. So 18/10/24 I have challenged.
Let us see the first one.
29/12.
First one is dated
29/12/23.
29/12/23, saying that the land for which I have applied, that is allotted to Rungta.
29/12/23. And another is
18/10/2024.
Let us face both these instruments.
Yes. Now, before that, Millards, may I show only the relevant pages, Millards?
Yeah.
Before your lordships reaches there, since your lordships are going with the chronology, Millards, so what events have transpired, Millards, may I show the documents? Now, Millards will kindly take.
No, how that is it?
Plus that will assume relevance.
Let us see.
Very well. Your Lordship will see that.
Because of Mohinder Singh Gill,
Yes.
we have to see the reasoning as contained in the instrument itself.
Yes. 172, I'm sorry, minutes. 190 minutes, your Lordship will see.
Annexure 21.
Yes, annexure 24. 26.
First is annexure 21,
21, 190.
which was annexure
190 minutes.
Yes.
22, which was annexure 20 in the writ petition. He has made it annexure 22.
In appeal, it is 21.
21.
Oh,
That's Miller's because the impugned judgment is annexure.
no issue.
To the Director, Abhirav Industries, allotment of land measuring 56 acres at IDCO for Abhirav Industries such and such to set up 1.2 MTPA and at Bhanjapali, Tahsil Koida, District Sundargarh. Reference
Once, in your clearance order dated 31/10/2023, is there any clause which says this is subject to variation?
I just see. Let's see that minutes. 139 minutes. Your Lordship will see the
139.
clearance order.
Is approved in principle.
In principle. Yes. The approved in principle minutes. Now let's make it.
How Apex Court has interpreted approved.
No,
in
minutes, it is
principle.
not final in nature, your Lordship. That it's not final in nature. Well, however, I show Miller subsequent documents where EPCOL also says that. State level single window clearance authority in its meeting held on 31/10/23 has considered the proposal of Abhirav to set up such and such with an investment of 231 crores and approved in principle the proposal subject to the following conditions. The company will clear arrear dues, if any, of the government before allotment of land for the project. No raw material linkage assurance from the government shall be provided. The project should not be located on mineral bearing area or command area of any irrigation project. Company will submit its action plan for implementation of the proposed project to EPCOL within 90 days of the communication of approval of SLSWC. The company will submit detailed land use plan, allotment of land to the project. Allotment of land to the project is subject to assessment by EPCOL. And my case is this assessment has already been done. And that is reflected in the EPCOL's letter dated 2/12/2023. So, because these are there, my lords may kindly take page 161, subsequent letter of EPCOL, affirming this.
One second. Sorry, can you read Annexure 21 once again?
My lords, 21.
Yeah.
Yes.
Is there any decision of any high court, sir, which construed the expression in principle? Just check it. Yes.
Your Lordship wanted me to see come to annexure 21.
21.
Yes. With reference to the subject side, Millers will see there is a reference to EPCOL's letter dated 6/12/2023.
21 is that one. 4/11/23.
21. Annexure 21.
Yes. That is a reference in retail.
Yes, my lord.
29/12/2020.
29/12/2020.
29/12.
Yes.
Allotment of land.
This is where they say that go and find an alternative land.
Let us see.
Yes. There's a reference to EPCOL's letter dated 6/12/2023.
Where is that letter?
161 minutes.
161.
161.
Let us see that.
This is what I wanted to show you. And let's see that 161. Although the letter is dated 2/12/2023, Malas will see in the next page, it has been signed on 6/12/2023. Thus, the reference of 6/12/2023.
In that reference there.
Yes.
In Annexure 21.
Yes.
What this letter says?
This letter, Miller's may just place it.
This is addressed to whom? By whom?
To CGM IDCO.
By
EPCOL?
No.
Yes, this is by EPCOL.
Your letter.
Page
Abhirav Industries Private.
Page 161. Annexure 15, please.
That is the
1.
which is Odisha here.
Yes.
So executive director
Of EPCOL.
he sent, it's an internal communication.
Mark to me, Milad.
Mark to you, you also.
Yes, yes, at the bottom of the page, at 160.
You are right.
Well, let's just read this. 6/12/20. Signed on 6/12/20.
Now, what was gist of it is what?
Well, let's hear. There's some. May I just read? This is a very short letter. May I just read? Subject is recommendation for allotment of land in favor of Abhirav for such and such at village Hanjapali, Tahsil Koida, district Sundargarh, with an investment 231 crores. In inviting reference to the subject above, I am directed to inform you that the SLSWCA held on such and such had approved in principle the proposal of Abhirav to set up 1.2 MTPA iron ore beneficiation plant with an investment 231 crores. The company had applied for 81 acres of the land at Tahsil Koida. The subcommittee examined the proposal by referring benchmarking reports, considering industry standards and request of the industry concerned.
You had applied for how many acres?
81 acres.
How many acres are granted to you?
That's 56 acres. Depending upon the area statement submitted by the company, we'll see that. Depending upon the area statement submitted by the company, the land has been assessed. The subcommittee has assessed the land requirement for project is 56 acres. So Millard's area statement, that what was the area statement given by me? I'll show that, Millard. I'll show that. Depending upon that, they said, no, 56 acres is what is given to you. So this area statement, when it was given, Millard, it identified the area or the plots that were supposed to be given. EPCOL sees that and then says that you get 56 acres. And it is also, Millards, not without any application of mind. With due application of mind, they say, no, you take 56 acres.
Yeah.
In view of the above, it is recommended for allotment of 56 acres of land for the project of Abhirav, which is approved in SLFC meeting dated such and such. The required documents for processing the above proposal are available in the GoSwift portal. The recommendation is subject to the following. Because there is again a subject to following conditions. Millards will see that. There is time is of essence, Millards, clause 2. If construction work is not started within 9 months from the date of possession, the lease shall be deemed to have been cancelled at the end of 9 months period by IDCO. Further, if the land or any part of it is not utilized fully for the purpose for which it is sanctioned within 2 years, the same shall be reverted to government IDCO free from all encumbrances. Then, Millards, next point number 5, Millards.
4 also.
4. The company has to obtain all statutory clearance.
All statutory clearances you obtained.
Yes, that is not in dispute. There is water clearance, everything is there. That is not in dispute. That is not even the case.
Abide by approval order.
Yes. That 4/11/23 letter that is.
Go to the letter. This is one which is, it's a reference letter.
Yes, this is the letter which was referred to by that letter at page 190, annexure 21.
190. Let us read 190 now.
Yes, well, we'll see 190, annexure 20. With reference to the subject cited,
21
annexure 21.
21 refers to that letter which you read at annexure 50.
Yes,
6/12/23.
Yes.
Now this says
that it is taken by Runta, you go and find another alternative land. And that is where I write of my objections, I raise objections, ultimately I had to prefer the writ petition.
No, this says, 21 says, 21 is issued by land officer.
IDCO. Despite the fact that the recommendation of SLSWCA is binding. And the SLSWCA comprises of the chairman cum managing director of IDCO. This letter is written by land officer of IDCO. Okay. with reference to subject, I am directed to inform that EPCOL has recommended land measuring such and such in the district of Sundargarh to set up such and such plant at Bhanjapali, Tahsil, Quetta Tahsil, district Sundargarh. In response to this office letter dated such and such, you have submitted the land schedule and map in village Bhanjapali under Quetta Tahsil in the district of Sundargarh. Said land has been already been filed under land bank category.
When already means when it was?
That they say they have done in July 2023.
July 23 is before your clearance.
Before my clearance is what they say, Millets. But Millets, any which way, that's a different thing. It's after my proposal. But here, Millets, I have to show, Millets, the challenge before me, Millets, is, as I put it to myself, is to show that when I submitted my proposal, Millets, to SLSWCA through EPCOL, which led to that 6/12/23 letter, where they said that we have done your land assessment, the area statement and everything we have seen. And we are saying you take this 56 acres. I want to show to you, Lordships, that whether I had defined the area, the very plots that I want.
Question is not that. This is where the doctrine of priority comes.
Yes.
Before rights became concrete for your client, because of the notification under Code 5, Section 4(5), if allotment is already made to another agency, opposing party, then what they have done is only rectification of the mistake. Therefore, we want to know when allotment was made to your opponent, Mr. Padi.
Recommending
I'll demonstrate.
I will show your lordship
to you.
the relevant documents which is not brought to your lordship.
Let us see. He is going methodical.
Prior recommendation is Rungta mine. That is the crux of the matter.
His recommendation was? Your recommendation was for which village?
Anjapali. That's my case. Their recommendation was through and through for commander.
There is no recommendation land specific. Your lordship kindly see.
Not been village specific.
Kindly see page 245.
Will come.
That is recommendation in favor of Rungta.
Why do you spend? Why do you spend? Why are you showing your card to him?
Lord, sometimes, Lord, to assist your lordship, to reduce the time. The crux of the matter is not brought to your lordship. That is why, Lord, I authorize.
My lords will kindly take page 74 of my rejoinder.
Now, just we want to know, since your brother is saying we are taking much time. Let us, no, there will be truth also. There will be truth also sometimes. Now let us see the truthfulness of Annexure 21.
Yes.
Unnumbered para 2.
Yes.
Is it true or not?
No, it is not. That's my case. Because everywhere they are not.
Where have you stated things to that effect?
Because that's my case. That is my case. It has never been allowed.
One line.
Yes.
Para 2 in Annexure 21 is not true. Show that.
That's my ground itself. There, my first ground itself is no third-party rights have been created in favor of Rungta, which can be construed to non-suit me. No third-party rights have been created. So that observation, of the Honorable Single Judge, with due respect, is incorrect. Is my ground of challenge that no third-party rights have been created. That letter that they are showing, may I just show Your Lordship?
There is difference between third-party right being created and something less than right being created. Now, the case falls under second part. It is less than, if at all, arguable, subject to what they will say.
If that is the case,
it is. They have not allotted it as such. Third-party rights are not created. But this is earmarked for X entity.
Yes.
That is available here. That also is not true.
What? The third party rights, if at all it is not created for either of the parties, then it cannot be said it cannot be said that Rungta has taken it. That ground that you are.
No, they have not said. It is filed under land bank.
That's the case.
Category A.
Their case is it is allotted to Rungta, which is not the fact. So there is no allotment per se. Let's very kindly see, Willets.
So
Communications exchanged.
Your first ground is it is not allotted to anyone.
No.
The first contention of the council appearing for the opponent is that the subject land is not allotted to OP number response number 8. Response number 8. At all. And to that extent, what has been stated in unnumbered para 2 of Annex 21 is not true. Correct.
Now, Millets will kindly take the rejoinder that I have filed to in response to EP call.
No, we'll ask them. Now, this is the first point. Then what is the second point?
The next point, Millets, is that I cannot be non-suited saying that somebody else is there. So therefore, you will not get. What is my case initially? My case initially before the High Court in the writ petition was a case of inaction. That you are not allotting that property in my favor. Then, Millets, the argument comes that it is already given in favor of Rungta. I will demonstrate, Millets, the land is not even alienated in favor of IDCO, let alone Rungta. It is not even alienated in favor of IDCO as late as 2025.
No, this land bank category A.
Yes.
Can you take us to that document?
The land bank category A is their submission, Millets.
Where is that?
We don't have the land bank category A.
Sir, you kindly come to your letter. You are for
let him complete without.
When you want to say something, you will say like this.
Well, first of all, I have to show your lordships.
That's all it. We want to know. Kindly assist us.
Yes.
Be kind to us. How you are saying this paragraph 2 in Annex 21? Go to Annex 21.
In response to this office letter number so and so, you have submitted the land schedule. That means they have submitted the land.
Read fully.
Yes. And map in village Vanjapali and Koira Tahsil. Under Koira Tahsil. In the district of Sunam. The said land has already been filed under land bank category A on behalf of Rungta Mines Limited. In this regard, you are requested to submit.
No, show that. This is filed with Land Bank A on behalf of Messrs. Rungta. Where is the document?
That is Land Bank A. That is earmarked.
Where is that?
As it is proposed by the Rungta.
Where is that?
Who is recommended earlier. Earlier.
Where is that?
That, my lord, your lordship kindly see the counter affidavit. My lord, that is Annex 29, page 237.
237 of the affidavit?
Yes, sir. This is our counter. Count.
Paragraph?
Then lordship kindly see, not paragraph, showing the documents. My lordship, just for a moment, kindly see page 245. This is the earlier recommendation by EPCOL for Rungta. This document is not shown to your lordship. Your lordship will find high level committee, then single window clearance authority. Everything is prior to this petitioner. Then lordship kindly see, this is the in respect of the petitioner. So that is the recommendation is at page 247. Every date your lordship will find comparing to this letter, his letter. He said that I will set up the industry as a Vanjapali, not that Vanjapali was recommended. what happens after this soft portal application recommendation is received, then they are asked, you submit your proposal where the land is available. Then he submitted the land at Bhanjapali. But before that, already Rungta had submitted all documents, everything as being asked, and your lordship will find at page 249.
That high-level clearance committee had a meeting on 9/1/2020.
My lord, your lordship looking at which page?
Mr. Padi.
Yes.
Just take
Yes.
your lordship.
Yes. And
Just
that's
to-
what high-level committee has decided.
Just to clarify. But he has been recommended by us, no doubt. State level window, I will just have the state level. But state level window does not recommend land specific.
Yes.
Does not recommend land specific. It recommends the requirement of a land. That means 98 acres, 56 acres, 90 acres. But his application, which I'll demonstrate to lordships, was for district of Sundargarh. His application original, which was considered. By then, my lord, we are also considered, he has stands in the same footing, both of them. That means I have recommended him for state level. I have recommended him also. That means wrong task. For state level, he is for expansion. He had an industry in 2000. He had an expansion. He had a
industry.
Yes, running industry with an expansion. So expansion, for expansion, I recommended him. If I don't recommend, I don't get. I recommended him 56 acres. I recommended him 98 acres. Now, whose recommendations are there? It's not land specific. After I recommend, they have to apply for a specific land, which they did. When I had recommended them, they had also applied for land specific. And they had land, when they applied for that land specific, that particular land, sir, was kept as land bank. That on the basis of their application. When they applied for the same land, then they said, that has already been gone to them on land bank. You apply for something else.
And it goes.
This is about 3 years. And last
apply
3 years.
this specific
And he came
form,
before, and he
give
came
the
before
land
your
where
lordship.
is available.
No, he came, this is the appeal. He came before this court, my lord, without implementing him as a party. He was not a party before the single judge. Honorable single judge considered everything and said that everything of his is prior. But there is no dispute about this state level, there's no, be it an executive or statutory power, there's no dispute on that. More is that there is a recommendation in his favor, there is a recommendation in his favor. There is an application he made, his application made. His application was prior to him. Does he have a right to get that, notwithstanding his application prior, notwithstanding the fact that it was been given by the land bank to him, I stand a better chance than him? Or is a comparative evaluation to be made? So what the ITCO did, Lord, that I can well demonstrate. That's the reason I said to your lordships, it's not land specific, Lord. First of all, Lord, what he's saying? He's saying yes to everything. When the lordships are, the most pertinent question, was the recommendation by us was land specific? His answer was yes, but my answer is no.
Land specific or village specific? Village specific?
No, it is not village area. No, only area specific. Area specific.
But it is village.
He applied the industry at Bhandapali. He applied.
I'll show to your lordship. His application may be anything. Our recommendation is land specific. Then he has to apply to it. We are not aware which land is available, not available. In our counter have stated so. We only say evaluate how much you need. 56 acres, 80 acres. Then you apply to ITCO who is in charge of the land. Then ITCO will say that yes, this land is available, not this land is not available. What the ITCO said here, sir, is that this land is not available because already been given to somebody else. And he makes a contest with him without implementing my party. And that's the
made a party at what stage?
He appeal.
In appeal,
they intervention. They filed applied intervention. They never be party in appeal. They didn't apply for the party.
My case, Millards, is there is no overlap.
No, if that is no overlap, then he's good.
He is for Commander, I am for Bhanjapali.
This is a confusion.
He's a
the existing industry is at Commander, Rungta mines. So that is why he is harping on that he requires for Kamada.
Millards,
But
may
for
I-
expansion,
That
it
is all is a case.
Bhanjapalli and
Right.
After, prior, after.
Koira.
It is
So
not-
this is
not
correct.
that-
May I continue making my case?
You suggested I will set up at Bhanjapalli. It recommended that yes, land may be given. And then IDCO says, in this prescribed form, you give your land schedule, everything, wherever it is available. But you made
There
the,
are other lands are there.
Whether the single judge mentioned about non-implement of necessary.
Yes.
party.
yes.
Mentioned.
That has been mentioned, but Millards, that ground today may not,
On
my humble
grounds,
view, may not survive because they are already parties.
No, only for limited purpose of seeing your conduct.
Yes.
You are not some villager or somebody, something like that, where you will not be much exposed to law, legal process, court environment, where you will not impede.
We have taken a categoric stand in that regard. We have said that in our humble submission, there is no overlap between the lands and there is no rights that we are infringing upon each other. And therefore, there is no requirement. However, we have invoked Order 1 Rule 10 sub Rule 2 of CPC, which says that if the court feels that they should be made a party, then the court may do so, is what our submission we have made before, and that is there. It's a written in our written submissions also we have mentioned.
So anyway, your writ petition was without a necessary party.
Is
Your
what?
stand is not overlapping.
Yes, it is
If
not.
it is not overlapping. Why did you come to court?
I'm sorry, please. Because
where did you inform them? Lands are not overlapping.
That is
Therefore, your letter you have issued. Please recall that letter.
That is why I have come. I have challenged that letter. And
where did you approach them saying?
Yes, please.
The lands do not overlap at all.
Yes.
There is no competition with that other person, respondent number 8. Where did you send that representation to any authority? Directly coming to court. That is the reason penalty level is increasing every day.
No, Millards. I have raised my grievance that before coming to court, that is at page 195, I had raised that grievance. 195. 22/7/2024. There have been other correspondences also, Millards. This is a detailed representation I made.
Where you say the lands do not overlap and therefore.
Millards will kindly see it is addressed to CGM land.
Which paragraph?
In inviting to the above.
Which paragraph?
Yes, please. Millards will see.
You need not read.
Kindly take page 196.
Millimeter, square meter, millimeter.
Kindly see page 196.
Yeah. Point out to that.
That's the fifth paragraph. Further, we have received a letter from your department with a letter number such and such 29/12/23. The letter your lordships read regarding submission of alternate land proposal of our industries as the land we have applied for has already been filed under category A on behalf of Runta Mines Limited. In this context, we need a clarification that how is it possible that IDCO, being one of the designated signatories of EPCOL and having seated in the SLSWCA and SLFC meeting, sending such letter after all the submission of documents before approving our project, our files have been passed through many departments for scrutinizing.
Overlapping word show that.
We are saying that it cannot be that.
Two things. It cannot be allotted to them is one thing.
Yes.
If your case is these lands do not overlap, you have no such right at all. How you are concerned with the apple cut of another person?
I'll tell you, Lordship. In their reply, Millards, kindly, Millards, that letter your Lordship saw, where they write about Runta. In that letter, there is no mention of any reference of a letter dated 13/7/23. Millards will kindly keep a note of that. 13/7/23.
Mr. Acharya, as it is understood from your amendments made in the application, probably before you floated your proposal to the nodal authority, you had already made a survey before the Tahsildar.
Exactly.
Seeking your land to be in Bhanjapalli.
Yes.
So how could you perceive that this village will be allotted to you?
Exactly, because That is
How
what.
could you, before the proposal is floated?
No,
You have not submitted the proposal by then.
The Tahsildar's report is with relation to Bhanjapali.
Correct. But your proposal was made in June.
I wanted to set up at Bhanjapali.
Oh, that is what?
Yes.
So you first
Because of the
surveyed it,
location of that
and
project.
it is at your instance
Yes.
that you wanted this land to be
Exactly.
allotted to you.
Exactly.
So
Exactly.
it is not the nodal agency.
No.
You yourself.
I wanted that. I applied to the Tahsildar.
So-
Please give the no encroachment if there is any encroachment.
If it is already allotted, two things.
That means, yes.
Let us articulate it little with a sharp knife. If your case is that these two lands do not overlap at all, then you have no business to assail the allotment made to that person.
I have not assailing.
No, you have assailed in the same. There is a wealth of evidentiary material to show that he has been already allotted the land.
What? Village commander?
No.
All of these letters are village commander. I'll show that.
They are industries at commander.
Kindly take Miller's.
They want
first one. Where do they derive their rights from?
Kindly don't mislead.
Let me show the papers.
Clarity.
This allegation of misleading Millets is being used very casually these days.
See, lawyers
I
generally
take
very generous
exception.
in employing the language.
Yes.
They are very generous.
But Millets, that shouldn't be Millets, in my humble
You
submission.
mean to say people should not be generous?
No, Millets, I am saying let them not be generous in these words, Millets. 339 is where Rungta derives their rights from. 339, page 339. The High Level Clearance Authority, HLCA, dated 9/1/2020. And this forms the substratum.
That the land in question was never allotted to Orange, much less it was linked to Ithaca. What is that? Ithaca.
No. Much less to say Runga. That is Ithaca. Ithaca.
He further adds, even otherwise, these two parcels of land are independent, and there is no overlapping at all.
Because one is at village, that's my submission, because one is at village commander, other at
one
Bhanjapali.
village, and the other being in other village.
Yes, village commander and village Bhanjapali. There is this commander, mine is Bhanjapali. Now, Millets, this is
Village, another is
Bhanjapali.
Yeah.
And in fact, Millets, village commander is here.
Yeah, just take
in between.
2 minutes. I have not.
No,
I have not done it.
Millets, may I?
No. We are all facilitating. We are all facilitating a lot. This is nothing.
Yes, is
No,
about
there is
the
a-
Facilitation Act.
because you're not a party. You're not a party. He has been a party here. He has filed an affidavit. He has now also submitted with the records and all his applications. Kindly see the affidavit filed by Opinamate at page 166. His application. He said that he had not applied, right? Because he is prior 166 of his affidavit filed.
Application.
His application. Prior to his application, OP number 8 application. So he said that he is not applied for that, his application. State level
Page
window.
number? Running page of the paper book?
Paper book means that are there affidavit by OP number 8, page 166. There are two things, so how it is, otherwise, all facts, all only on facts. If you 166,
This is
165 is dated 6/6/23, much before everything had been happened to him. 6/6/23.
I have also annexed it in my rate appeal, page 252, Your Lordship.
Kindly see, sir.
252 of the rate appeal. I have also annexed it.
Okay, same thing. If you have the next, it is there in record, you will
this
see.
letter is not in dispute.
Yes.
No, there's no dispute.
No dispute.
But this shows their application is.
My submission is,
Not before.
these are submissions to be made through Go Swift portal.
How?
What is
These are not issues.
what is exceptional about it, that it was submitted physically.
How does, this is not a case. You have not met Rangta party and met all this. But 6/6/23,
his application.
Our Karnataka High Court has rejected this contention. Where one has to apply prescribed only e-portal. But here the physical copy was given. And that was favored. That was challenged before the Karnataka High Court. Unfortunately for you, I was the judge.
You know, the rest.
I
623. 6623. Yes, by
that judgment.
Yes.
By 6623, after his state level window, after recommendation of land of 98 acres, he makes his application to ITCO. That's the procedure. Village Vanjapalli, he has applied. Your lordship get it at 175. He's the same document he's saying he has annexed. Page 175, he has applied for 175. Kindly see, page 175. These are the application. He has given the application for Vanjapalli. He said that he has not applied for Vanjapalli. He has applied for Vanjapalli. Your lordship get it at 175. Please, I'm clarifying the factors.
Don't dispute these things.
No, you are not disputing or not saying so. 175 I have applied. Now, my lord.
Now we need a little time to digest what all you
No, it is a very simple, sir, for your lordship.
I have a digestive formula. If your lordship don't mind, 2 minutes.
No, Milaj, may I finish my arguments?
Just see.
May I finish my arguments? That's my humble.
Just see.
There is more. Because I was submitting
and land bank is earlier. Everything is earlier. Now he wants that particular land.
You're on the left side are the various events. Now submission of proposal or project proposal in online EPICOL. I do on 27th March / 24th April. Your lordship have it, notes. Look at the right. When he files
2623.
So 2 months after, and then this has to be read, corrected. If your lordship sees the footnote, Millards, he filed a corrected petition on 10/7/23. So it was an incomplete application 4 months behind me, after me. Now kindly look at the next one. His in principle approval I got on 8/5/23. He got on 31/10/23. Look at the third column. Assessment of land by EPICOL. My learned senior said EPICOL will only assess what is the quantum of land. So he got 98, I got 98 Millards on 25/23 and he gets 56 7 months after on 2/12/23. And if my lords kindly turns over the page, Millards, I get a communication from IDCO to give now the details of land because IDCO will now collect. So I was given this on 29/5. He was given on 30/12. Now application of land I make on 6/6/23. He makes 6 months after. And Millards, and therefore Millards, on 13/7.
More specific, Mr. Parija. You could have said 6 months, 6 days.
I'm great. I'm great. So every time he is behind me, Vanjapalli is 1,000 acres. Nothing stops him from taking another.
If it is not overlapping, why is not overlapping, he says. So let it not overlap. Let him go anything in Vanjapalli.
May I demonstrate this? Just before I resume my
argument. For not making a party.
Yes.
Start with. He can't challenge him without making a party.
Very good. Now, Millards, may I just, before your lordships.
Learned Advocate General is also waiting. We'll have this matter. Now we have understood the case.
Only thing I want to leave your lordships with a thought. Only thing I wanted to leave your lordship with. Your lordship will keep it as a part and take it up, Millards.
Tomorrow.
Advocate General is waiting. Lawyers for employees are the way. Some of the employees have already retired.
Yes.
Dead also.
I have pattern better.
That this is also pattern. Yes, lordship.
That may be taken up after tomorrow.
At 2 o'clock, Millards, tomorrow.
2 o'clock, I have a matter fixed.
We have both government, we will help each other.
Now, Millards, I just wanted to leave one thing as a parting note. The Rungta plant at village Kamanda is here. In between there is a hill.
That's a hill.
Are
you challenging that allotment?
And here is village Vanjapalli. The case of Rungta is they want to set up a tailing pond, crossing that hill, which incidentally coincides with the same land where I want to set up.
I will not trouble that hill. The lordship is
No, no,
saying.
which incidentally, it's a 7 odd kilometers.
That's a different
And they
issue.
want to set up that tailing point there, incidentally at the same place where I want. And the name Bhanjapali in any of the correspondences relating to Rungta, first time comes after I put in that application of 2620. Before that, I challenge Willots myself to find whether there is any single document relating Rungta to Bhanjapali before my application of 2623. If I find anything, Willots, tomorrow, Willots, I'll withdraw this case.
As such, you need not have failed. You'll also take over 2 o'clock.
2 o'clock. Is that written note, Willots, I have given?
You have written, okay, we'll read and come back to. Yeah.
To recapitulate your lordship's memory,
Yeah.
I was submitting to my lords that several rules framed under the Orissa Education Act are interlinked. Rule 3 of the 81 rule is not to be read in isolation. But so far those aided non-government institutions are concerned, that it has several nomenclatures. Really, somebody will take some time to understand so many rules, so many
Complex.
it is really complex. Even for me also, most of the things I am yet to learn. It's too difficult. Even secretaries, they join after 2 years also, they themselves do not know what are the intricacies of the department. So that is why, my lord, I was proposing 2 things subject to your lordship's approval. So I have to place granting aid order 94, 2004, 8, 9, 14, 17, and not less than 7 rules, my lord, which is directly linked, including the recruitment rule, the GPF rule, because your lordship knows for the purpose of pension, an employee should also contribute to the general provident fund. It should be a pensionable establishment. There is a GPF rule. Those, my lord, category of employees before your lordship, they are not in the GPF fold. Only a block sum, a block amount is being given to them, to the governing body or the management, which in turn is paid to them. Because I have also, yesterday your lordship was putting that query, how they are paid, what is direct payment. So therefore I was proposing, my lord, that is subject to your, I was told that your lordship would not be holding court from 6 to 9 or something like that. I was told 1 week, full week. So there are 3, 4 to senior counsels to respond. I will give a rejoinder reply. It requires time. So in the first
I am
clause,
concerned, I'll take only 5 minutes.
no, let them take. I was just because I'll be not. It's public time. That is why. That is why. No, I am not adamant. Please don't use. You are also the agent. Oh, I'm sorry. I'm sorry. I apologize. No. बुझेनी बुझुची जे शब्दटा बेले बेले ଆପଣ ରାଜୁଛନ୍ତି ଏତେ ସିନିୟର ହେଇ ଏତେ ଆପଣ you are holding ଆପଣ ଯାଇ I misheard. I misheard. So I'll file a written note also because no counter was filed in the court below 400. Chief Minister also, the entire, the committee, therefore we set up a committee. How much has the...
What committee did? Sure.
No. Committee has not submitted its full-fledged report. They're examining. There are several associations, teachers associations. So we are government. Yes,
should get the
government is very sympathetic and considerate. Let me be very frank in my statement and bold. We have to work out what would be the scheme, because pension has to be a scheme. There is no. Yes.
That's all right.
Yes.
What your committee did? When did you constitute the committee?
No, committee.
Assurance to the government.
No, committee is a complex 72 kind of type of problems they have. They have given memorandums, 7-8 associations.
No, what you have done? Where is first meeting held?
No, it is going on, Milord, because they are listening, hearing them. They have opened an office. They are going and, Milord, it is going on. The process is going on. Committee is, Milord, it takes time. Milord, 70, 56 years, 7 decades of problem, it can't be resolved in a month or two. They have to, it's a very larger issue, Milord. Granting head concept, it's, Milord, it is very difficult. Who is grant? State has also limited resources. We can't, Milord, that, Your Lordship. That is why 7C was introduced. And that has been, Milord, the Supreme Court in Anup Senapati has dealt with it.
We should not waste our time.
And that's correct.
Many poor people.
Many cases are urgent.
Will I be permitted to? No, I will tell our view first. We'll argue our case first.
Before Your Lordship says, only one small prayer. On our behalf, Mr. Buddhadev Rautra may be given 15 minutes. And after that, Your Lordship feels that any more time is required, Your Lordship do whatever.
I will take 3-4 hearings, 3-4 dates. Try to understand. It's not that easy.
Matter is 60,000.
Yes, 4 dates.
Absolutely not correct. I can say
astronomical figure is that without data, how many persons who are retiring, which year is retiring, everything is said.
No, it is not there. Everything is not said in the judgment.
I am making a submission, Mr. Acharya, to the court. Please allow me.
Sir, the unfortunate part is some of them are dead, Your Lordship again and again repeatedly said. And the matter, whenever the matter is being taken up, there is some adjournment, Your Lordship look to the order sheet. And Your Lordship heard this matter in extensio. Your Lordship also expressed Your Lordship's view that...
It's only beginning.
Express Your Lordship's view that you please clarify about this. Now today they say that 2004, 2009 will place all the rules. What is the purpose? With all respect to the seat of the advocate.
Cases are not. Yes, they are participating. They are appearing before the committee.
Sir.
No, I have only 60. I pray only 60 seconds.
Any of your association is appearing.
I want to bring to your
association appearing
for the committee
occasions.
That is not relating to pension alone. That is regarding the entire educational system. That is why he has been telling me that has nothing to do with
Sir, so far the pension is concerned, it has nothing to do with that. That is why Your Lordship directed to produce. Then Your Lordship modified that order. Why you will make some comments on the officers? So only question is 81 rule is applicable or not?
That's not one of the agenda.
That is the wrong in the judgment of the single judge.
Sir, I am appearing 2-3 cases where one is suffering from cancer, another is in death bed. But my respectful submission before Lordship is, in 3 occasions we have heard also, it is recorded in proceedings. Our beloved AG submitted that 7 lakhs employees
today rightly presented, although they have filed affidavit before the Supreme Court, that is around figure of 41,000. But rightly they have said the 50,000. Why I agree to this? 50,000 employees to get the pension. That is a separate thing. My respectful submission before Lordship is, after Sharath Freda, the Honorable Single Judge examined the matter, not that differing with the Sharath Freda, but the division bench remitted back the matter to the single bench again to be heard. And thereafter, counter filed, rejoinder filed, everything was displayed. Thereafter, a judgment was delivered. My respectful submission before Lordship is, if at all they have to consider by a committee, it is their liberty to do so. But how could they have not given any remark as certain provision has been violated or there is a perverse finding? There is no such pleadings to that effect. Such a provision has not been considered. That despite that, we are suffering. One of my client is 14, retirement is in 14. He is in deathbed. He is not able to speak even. But your Lordship kindly appreciate this aspect at least. There is nothing, if your Lordship will allow 5 minutes, my Lord.
No, but for you, 5 minutes, for Rautrai only 20 minutes, all right. But question is, if learned Advocate General says, maybe justified of, we don't know. He says, the enormity of the matter, that warrants argument for 4 or 5 days.
Yes.
Therefore, this bench may not be possible to hold the way.
No, my Lord, it is not 4 or 5 days.
Why not? You will stop me from arguing.
It is an appeal. Whatever the learned advocate will say, that's a different question. It is an appeal. Whatever pleading was pleaded before the single judge or before the division bench earlier, because the matter was remitted back.
There was no counter. How could there be?
And after the
pleadings were not
remitted from the division bench, a counter was filed, rejoinder was filed. Can they argue something which is not in the counter, not in the rejoinder, not in the order? And your Lordship rightly yesterday put that question to the Learned Advocate General. You say that what is the wrong committed by the in the imperial order. And you please place that order. That was not placed till today. And matter was argued extensively yesterday. Now they say that I will take 2004, 2008, 2009.
As an outgoing judge,
Outgoing judge, your Lordship, as on today,
that we are interested in hearing this matter, that matter. See, we have done other matter also.
No, your Lordship, I am conscious that your Lordship is asking time and again that we are hearing that service matter because they are going to retire and some people have retired.
No, but yes, we are learned single judge. Learned Advocate General, if he sincerely feels that matter requires greater length of hearing because of the enormity of the whole that you could put into state's purse, then he may be justified. We can't say like that.
The whole question is, that is why I'm saying you also see that entire pleading what they have pleaded. Now they want to say just to expand.
We will fix
I have a provisional, I have an interim application that is coming, my Lord, with provisional pension. Let them pay, my Lord, the provisional pension and let it be added. Let the committee be considered. That's there, my Lord. What will do? The right to livelihood, you will not.
Way back,
right.
When I was a student, I heard about B.K. Krishnan's ability of filibustering about the Kashmir issue in the UNO. And if filibustering is a part of the legal argument, I do not know. That is all that I can say.
You know better. You have already functioned for 5 years. I do not know. I know my limitations.
I don't do. I'm happy that I have already gone out because I do not want to inherit the
So why don't you come back? You are most welcome.
No, I deserve it. This is
You'll be doing the same thing which I am doing now.
Some regular bench, let some regular bench hear this matter because this matter was heard for some time on some occasion, including yesterday. First time. Today, Learned Advocate General Mr. Acharya very passionately submits that the matter has founded both in terms of jurisprudential propositions and also the financial burden that would be placed on the shoulders of the state if appeal be adversely decided. First time, he, in so many words, submits that at least 4 or 5 hearing days are required for completing the argument regarding head to the complexity of legal issues involved. First, since one of us is debiting office shortly, one of us people with PhD shortly, it is desirable that this matter be heard by some other bench on a day-to-day basis.
May I request, first we can, if that is so, first we can place before the Honorable Chief Justice to at least place this matter so that we can hard day-to-day basis next week.
There is a proposal from learned senior advocates appearing for the employees, respondent employees, that many of their clients have retired and some of them are dead and gone. And some are suffering from terminal diseases like cancer. And therefore, this matter be heard on priority basis and speedily. Custom. Next paragraph. In the above circumstance, we request to special pitch. In the above circumstances, we direct the registry to place the appeal papers at the hands of Honorable the Chief Justice for consideration. Immediately.
I'm sorry, in fact, I lost an opportunity
Sometimes maybe right also, we can't say.
Because
See,
it would have been my great pleasure.
but
at
the
that
only
time.
thing is that saying that we have not filed our objections, this, that, that.
No, it can be also
It means
Milord
hundreds of
decided
matters
because
state has not
that's
filed
correct.
objection. How long the poor employee should
No, that's Milord. Then in that event, Milord, everybody will come. Now it would invite not less than, let us assume 50,000 cases would be filed. So let the law be decided. At
It
least
has to be given, irrespective of the number of the employees.
that's. So, Milord,
Anyway, we feel bad because some.
I again, Milord, my apologies for.
No, not only that, because people have expectation. The employees, many are dead, some are suffering from cancer.
We are, Milord, kind enough. Your Lordship may believe me, certain steps we have taken in the meantime, it is in the process of deliberation. What would be the fate, whether it can be met out? There are discussions going on. The
Anyway,
employees
we will not say more.
are deep employees.
Okay. Yeah.
Metro has observed 25. Metro has referred also from 30th. And as per your direction, I have already solved a copy.
2 minutes. That's
I have already solved a.
Wait.
The matter is that the petitions have been removed from their house by taking physical possession. So hearing a lordship has directed to solve a copy of the bank council.
They were staying in clubhouse.
Clubhouse, that case.
Then they went to Bhubaneswar.
Bhubaneswar,
What do you say?
But here, my lord, still from this.
You allow them permissive occupation, you allow. It will not be possession. Possession will be with you only. You allow them, give them permissive occupation. So that for a short period, they will make some arrangement and then they will go. Suppose if you occupy suddenly, if you throw them off, how they will go? Where they should go?
In fact, the process has been followed. They don't oppose to the proposition for the short-term accommodation, but process has been followed. They have never challenged the process. In fact, the total outstanding is 33,81,000. Where even I have taken consent from my instruction from my client. So I cannot put it on record, my lord. On 22 lakh, we can settle it.
What do you say? From 32 to 22?
33 to 22.
11 lakhs.
11 lakh, we are compromised.
What do you say?
1 lakh. Actually, what happened, my lord? On the that date I have stated, the loan was granted in favor of that person has expired, my lord.
That's true. But loan liability continues.
But now at this time, Nobody is earning member is there, man. Yesterday,
I will give you short accommodation and within that you search some house and go. We'll give you about 4 weeks time. You be in the house instead of residing elsewhere. And within 4 weeks, you find out a suitable accommodation, quit the house.
by the time I only pray, I made an application to the one-time settlement.
That is what they have said now.
If something is...
What else? What else? He has already said. He himself came out with one-time settlement.
Yes, but not possible.
But they say it is also not possible. No, it's a very weak case. If you want some short accommodation, we'll give you.
Yes,
where you will reside in that house. And this is only to facilitate that you will see some other house in
Humanitarian.
Humanitarian ground. It is only occupation, but possession of the land, property will remain with the government, the bank itself.
Man.
All right.
And on that,
we'll give 8 weeks.
The possession was taken in 20.
Very well. Possession, you
put it on
your immediate possession is with you. Immediate occupation is with them. There is difference between possession and occupation. 2018 Supreme Court. Therefore, only occupation we have, it's a permissive occupation. Anytime with your people, your officials can go search the house, whether they have damaged, etc. All right. So that
And on the
where they should live.
Absolutely. On the day, fourth day, the completion of the fourth week, my lord, they have to hand it over to you again, my lord.
Immediately they should do it, otherwise police will do that.
is there for auction, but not fair.
Then what they should do? Not fair means what for you had given the property for by mortgage.
My client are also not in a position to
But the house be sold. Otherwise, if we say the house should not be sold and you should be permitted to reside in the house, we are giving you 8 weeks time. 2 months. Within 2 months, you search some other accommodation and shift to that place.
I'll hand it.
Petition prayer reads as that. We had issued emergent notice other day, and on service of the same, the bank has entered a parent to its parliament council, who vehemently opposes the petition, contending that the possession of the property has been taken in due course, and therefore whatever hardship the borrowers are put through cannot be taken cognizance of in the face of law. First, at this stage, the counsel for the petitioner submits that if a short accommodation is given for staying in the said house by way of permissive occupation, as contradistinguished from possession, justice would be meted out to the clients who would look for alternate accommodation in the meanwhile. First, there is a sense of law, logic, and reason in this submission, which is very innocuous in as much as the possession of the property in law and fact would remain with the bank itself, notwithstanding permissive occupation to be given to the petitioner borrowers. First, in the above circumstances, this petition is disposed of, directing the bank to grant permissive occupation of the security property to the petitioners for an outer limit of 8 weeks. First, the petitioners shall peaceably and voluntarily quit the occupation, yielding actual possession to the bank without creating any hurdle nor causing any damage to the property in question. First, it is open to the OP bank to supervise the property even during the occupation by the petitioners. First.
8 weeks.
Well, the 8 weeks, but no further extension on any pretext.
The petitioner shall not make any prayer for extension of the period.
And also allowed to for valuation, conducting valuation in case.
And that they would not come in the way of the bank conducting valuation and other processes in accordance with law. Okay.
The materials,
Instead of 8 weeks, we will make it
the
2.5 months.
if we hand over, we can take our materials from the house by that time.
Why you go and recite, go there, then you take.
The intention is making clear that he wants to take out the.
No, other property.
No,
Other
asset,
property,
Other property.
my materials.
Unchanged property can have.
We make it very clear that what is being mortgaged is only the immobile property, comma, it is open to the petitioners to take
Uncharged asset.
movable articles.
Uncharged asset.
Huh?
Uncharged asset.
And uncharged things when they quit the property. Okay.
In the meantime, if we made an application for one-time settlement, then it's not a bar.
Will not come in the way of last month. The bank sympathetically considering petitioner's application for OTS in accordance with extant RBI guidelines. Last, in the event the petitioners fail to quit the premises immediately after the expiry of the period above specified, comma, the jurisdictional police shall arrest and detain them to ensure the possession being delivered back to the bank, comma, a copy of this order being produced. Okay. If you do not quit, then police will quit. They will detain you. All right, we have made that point.
We're taking all steps to compromise.
No?
That's why I pray that in the meantime I will make a.
Now we have given 8 weeks to you. All right. Mr. Panda, anything? No. That will be to your house.